Justice of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All present have a business before this court with all hearings in attendance, and they shall be heard.
First case for argument is case 822, People versus Davis.
Again?
Just wait, we're waiting
All right.
for your opponent who is appearing remotely. Okay. All right. Mr. Bellatier, you may proceed.
Good morning, Your Honors. May it please the court, I'm Anthony Bellatier, appearing for the appellant Shahoni Davis. The first point in my brief is that the record does not demonstrate that the appellant.
Okay, Mr. Bellatier, let's assume we get through that the waiver is invalid, and we also find that the court implicitly found eligibility. Tell us why your client deserves YO.
You want me to proceed to the point about why she should be granted youthful offender treatment?
Yes.
That's what I'm interested in, yes.
All right, that's fine. So looking at the Crookshank factors, the only one that is in any way against my client is the severity of the crime. Obviously, the result of the crime was extremely severe and resulted in the tragic death of two individuals.
That seemed to be the basis of the court's decision. The court did reference the severity of the crime, so that seemed to be the focus of the.
That seemed, in fact, that was unfortunately, that was the only thing that the court focused on.
Right.
However, there is no evidence that my client had any intent whatsoever to cause harm to anyone. Although she took full responsibility for having her part in this, she never intended to harm anyone. She was 17 years old. She had no prior criminal record whatsoever. She had not even been arrested.
We know the facts, Mr. Bellatier. We know the facts very well, just so you know.
Thank you, Your
In terms of the consideration, we've really looked at it. The question is, as I understand it, the only choice we have is to either stick with the 12 or go to 1 1/3 to 4. Is that right? For YO?
That's the maximum, is 1 1/3 to 4.
Okay.
And she's
severity
current.
of the crime, some would argue, is probably, pretty bad, and therefore 1 1/3 to 4 is kind of light, wouldn't you say?
I do not think so, given her particular background. Particularly, Your Honor, asked that you take a good look at the report that was prepared by the Center for Community Alternatives. It's really an extraordinary document. It goes into her whole background as a child, that she grew up in an atmosphere of domestic violence, abuse, sexual abuse, suffering from post-traumatic stress disorder. It's just incredible what this person went through.
Yeah, Counselor, you make a lot of good points along those lines, but you don't ask us to reduce the sentence at all. You don't ask us to reduce it in the interest of justice. So a lot of the arguments you're making for YO would also support a reduction in the sentence. She got 12, the minimum was 3.5, but you're not asking us for that, correct?
Well, I would much prefer that you grant her youthful offender treatment, not only because of the length of the sentence, but because of the ability that will give her to rebuild her life.
Right. So it sounds like you're intentionally going all or nothing on this, either
No,
YO.
no, I would, if that is your interpretation, I would just say that obviously this court has the inherent authority to reduce the sentence in the interest of justice. And if that is what you believe is the appropriate remedy, then I would certainly ask that you do that. I would, however, hope that you would sincerely consider granting her youthful offender treatment so that she can have the additional remedy of not having a felony over her head, starting from the age of 17 years old, with all of the horrendous abuse that she has suffered. I just would hope that you would consider that. But obviously, if that is what the court is inclined to do, then I would request that you do that.
Okay.
And reduce her sentence to what you think is appropriate, given her
All right.
background.
All right, I think we have your argument. Thank you,
All right,
counsel.
thank you.
Ms. Ballin.
Good morning, Your Honors. Darian Balin on behalf of the people. seems that the court is most interested in the youthful offender point, I would just like to make a pitch that the totality of the circumstances here, especially the fact that defendant had acknowledged that she spoke with counsel. There were multiple off-record discussions with counsel about the appellate waiver, that among the other Thomas factors would make this a valid waiver of appeal. But turning to the youthful offender status, while the court did weigh the gravity of the crime over certain other factors, it took those factors into consideration. It specifically referenced the Center for Community Alternatives report. It listed every factor that it knew it was required to consider, and still used its discretion to deny youthful offender status given the gravity of this crime, where this court is, aware of all the facts here. The defendant was the initial person to set this scheme into motion to lure these two boys to their deaths.
Right, Ms. Ballin, can I ask you this? Ms. Ballin, can I ask you this? Do you agree with counselor that we have the inherent authority to modify a sentence in the interest of justice, even when the defendant in his brief does not ask us to do so?
Well, Your Honor, I wouldn't agree that if it was not an issue, if defendant didn't raise the issue on appeal and was not asking for that in the first instance, then it should not be something that this court considers.
And that's because you didn't get a chance, you have not had a chance to argue in opposition to it?
That's correct, Your Honor. I mean, I can certainly address that if that's something you would like me to. I think my arguments would be very similar to why youthful offender should be denied, especially looking at the gravity of the crime, the manner in which it was committed, this scheme that they hatched to rob these two young men, and then ultimately they were murdered over this. So all those same things that would weigh in favor of denying youthful offender, I think would weigh in favor of a reduction of the sentence as well.
Okay, I think we have your argument.
Thank you so much, Your Honors.
Thank you. 823, People versus Allagood.
Good morning.
Good morning, Mr. Keem.
Brad Keem for defendant appellant. I'd like to focus on point 4 of our brief, in which we assert that the trial court erred in imposing consecutive sentences concerning criminal possession of weapon 2 and murder 2. We assert that the evidence didn't demonstrate appellant's separate and distinct possession of the pistol from the shooting. Not a single one of the people's 20 or so witnesses observed appellant with the pistol that night. Appellant was searched
Before the shooting, or at least not immediately before the shooting, right?
Correct. A bouncer searched him, video, surveillance, cell phone footage, nothing showed him with the gun before the shooting. DNA on the pistol, mixture profile of 3 people, appellant, the alleged victim, and another mystery individual.
I think the most that can maybe be said is I think there was some proof that they saw him walking maybe in or around the bar with his hands in his pocket.
Yeah, and I don't think that's enough. We don't know what he was reaching for in his pocket. It could have been gum or a mint, or we don't know. We do know that appellant made some remarks in the pre-sentence report. He said that he possessed the gun, but again, not when. He didn't say that he possessed it before. And the appellant did have friends that were at the bar that could have passed him this weapon. We don't know. It was a melee. The pre-sentence report, that information too is not tested by oath. or examination. I think that the court really shouldn't give it much credit. I think instead, the second department cases, Harris, Ross, Breeze, King, those are kind of the ones that I would rely on because they have the footage and they have a lack of real evidence demonstrating possession before the shooting.
Okay,
Unless there are questions on the other issues, then I'll rely on my brief.
okay, thank you. Ms. Mervine?
Good morning. May it please the court, Leah Burvine on behalf of the people. In regard to the consecutive concurrent sentencing, I would just note that the gun in question, as this court can see through the exhibit, is a Beretta Tomcat. It is a very, very small gun that is about the size of a cell phone, easily capable of being secreted in a pocket. And here, there's testimony in this case that the defendant reached into his pocket at the time that the shooting started. There is no question based on that testimony that the defendant was in possession of the gun. I would also note that the cases cited by appellant in the respondent's brief, Breeze King was a case about unlawful possession, and that is because the shooting appears to have taken place in a barber shop, which was the place of business of that defendant. That is not what we have here.
Can you tell me with the testimony that you refer to about the defendant reaching into his pocket?
Yeah.
When was that, what's the timing of that act in relation to the shooting?
Justice Peridotto, that occurred right before the shooting. So there was the speculative statement that defendant may have been past the gun. However, I believe it was the bouncer, Mr. Nelson, who testified that he went to eject the defendant from the club. He had moved his person physically towards the dance area and saw him reach into his pocket. And that's all outlined in our brief. I would note also that the defendant was later in possession of that same Beretta Tomcat 2 blocks from the club where he was attempting to get a ride. So from the time that the crime was committed, he was in possession before and after the shooting, which had nothing to do with the shooting in this matter. I would ask that this court keep the sentence consecutive. I would also note that Harris, which is cited by the appellant, is a second department case that has negative treatment, and I would ask this court to not follow that case to the extent, if any, it would apply.
Okay, thank you.
Thank you.
824, People versus Settles. I'm sorry, Ms. Davison, you may proceed, sorry.
Good morning, may it please the court. I'm appearing on behalf of the appellant Derek Settles in this case. I'd like to first reiterate our position that the use of the grand jury testimony of Kaishia, I think that's how you pronounce her name, Kaishia Parker, at trial was improper under Fitzpatrick. I think it paralleled the use of the grand jury minutes in Fitzpatrick and was meant simply to bolster the people's case, where she was repeatedly queried and simply said, "I don't remember." And
Yeah,
I think that
the people take the position that, your position is that, this didn't disprove a position. They wanted her to testify to help their case, to add to their case, and that's not the standard.
Correct. And if you consider the question of credibility, the fact that she says, "I don't remember," doesn't go to her credibility. I'd like to also address the question of the consecutive sentence that the the court did not impose on the lesser offense. The court in sentencing specifically differentiated my client with his co-defendant, Mr. Johnson. He said, the court said, this sentence will be separate and distinct from the sentence pronounced with regard to Mr. Johnson for obvious reasons, but
Yeah,
also.
So, what's interesting is that he says for obvious reasons, and the record to me doesn't seem terribly obvious. Because he could have been distinguishing the sentences because the post-release supervision would be different because they had different statuses.
Or he could have been distinguishing their conduct if he believed, for example, Johnson was the shooter, which was not made clear at the trial testimony. I know the people take the position that it was my client, but the proof at trial did not show that in particular. But I think in any event, sentence has been imposed and sentence jeopardy attaches. So the suggestion that it should go back for Justice Doran to clarify that is improper. That in fact, he did not pronounce a consecutive sentence. And since he did not specifically pronounce a consecutive sentence, one should not apply to this case. In the alternative, I would suggest to the court that it has the discretion to modify the sentence by requiring that it be served concurrently for both of those purposes, because sentence jeopardy is attached, but also because my client is not a predicate offender and may have had a less egregious role in this matter.
Okay.
I rely on the brief else for the remainder. Thank you.
Thank you. Mr. Eagleston.
Good morning, may it please the court. Chris Eagleston for the people. The first thing we'd mention, of course, is that the primary issue of contention is unpreserved in this matter, that being the impeachment with grand jury testimony. We'd also argue that it was proper in all respects. The issue, as we see it, is whether it was materially damaging, and we believe that it was. And if it was, then of course it was admissible with proper limiting instructions that were given. It was materially damaging in this case because Kaisha Parker's testimony was the only testimony that places the defendant inside the crime scene where the shooting took place.
Right. So she was, you wanted her to offer what would have been helpful testimony. I don't dispute that, but I'm not so sure that certainly didn't disprove, at least not in total. I think some of her statements did, but not in its entirety. It didn't disprove the people's position.
I'm sorry, Your Honor, disprove our position regarding whether Mr. Settles was in the apartment at the time of the shooting?
Well, there were a number of statements that she backtracked on from her grand jury testimony. So there were, with respect to some of them, they didn't disprove your position, but with respect to others, I know it would have helped if she stuck with her grand jury because it would have helped the people prove their case, right?
Certainly. Absolutely, it would have. I mean, I first note that this isn't something where she was merely claiming she didn't know. I think, as counsel might have previously indicated, as her testimony began, she denied 3 times even knowing the defendant Settles, which was obviously contrary to her prior testimony. Regardless, we, as we said before, believe it to be unpreserved, and of course, proper limiting instructions were given on multiple instances by Judge Doran in this case.
How about the
Beyond that, the people would rest on their papers.
Okay. Thank you.
Thank you.
$825 people versus, I'm sorry, yeah, $825 people versus Woodward. Good morning, Ms. Hallenbeck. Oh, I can't hear you. Can you hear us? Okay, we cannot hear you. You have to.
Your Honor, this happened with some parties last week. We
Okay.
might have her dial in on the phone, but it takes a little while. So,
Okay.
you know,
So how about, we're going to recall this case because we're having, well, Ms. Hallenbeck, we'd like you to try to dial in. Will she be able to, can she hear us?
Yes, Your Honor.
Okay. Okay, we can't hear you, so I'm going to recall the case and I'm going to ask you to try to dial in. Okay. Okay, so now calling 826, People versus Myers. Mr. Hinman.
Good morning, Your Honors.
Good morning. You may proceed, Mr. Hinman.
Thank you, Your Honors. Unfortunately, I can't, wait a minute. Now I can see everybody. Thank you.
Great.
Your Honors, with respect to this matter, I believe that the people's misapprehension concerning the issue of effective assistance of counsel. They allege in their brief that whether or not defense counsel made any efforts to secure expert testimony is outside the record. It is not. It is clear when Judge Castro inquired of Mr. Griffith if he had obtained, had somebody ready in the previous trial, Mr. Griffin indicated he did not, and that he did not have anyone now. And that's at page A170 of the appendix.
But there may have been a reason for that. He may have chosen not to have any expert ready, or he may have just chosen not to call such an expert because such an expert might not have been helpful to his position.
Well, my position on that would be that if he didn't believe that expert testimony would be helpful to his position, he wouldn't have asked the court for adjournment to gain it. And it's clear that it was never looked into by Mr. Griffin. And the same is true with respect to the failure to serve a notice of alibi. There's no possible strategic reason for not serving a notice that the court is going to find to be required, even if you're only playing it safe, if you don't think that it really is an alibi testimony. There's no strategic reason whatsoever that could be legitimately advanced for not doing what needs to be done in order for that testimony to be available to the trier of fact when it goes not only to Mr. Myers' whereabouts at that time, but also to the credibility of the complainant, which was the thrust of the defense, was that she was not credible, that her allegations were contrived, and it's totally contrary to that to not serve what would need to be served to allow someone to testify. Having said that,
didn't Mr. Griffin indicate that the reason he didn't serve the notice of alibi is that he didn't learn of this fact that the defendant got picked up at 1 a.m. by his sister until later, until the trial, till it was too late to serve the notice?
I don't recall that. That's certainly, I don't recall that, but if that's the case, then I would indicate that, and I was about to go into this, that the courts, if Mr. Griffin really did not know of that testimony until that point in the trial, then I would submit that it was an abuse of discretion on the part of the trial court to preclude the testimony rather than giving in the adjournment that the court had previously indicated would be required in order to give the people the opportunity to look into that testimony and be prepared to counter it. Preclusion is a very drastic effect, drastic remedy that should not be imposed unless there's truly egregious circumstances. And here at best, if that is correct, then what it is a misapprehension or a lack of knowledge by counsel of what was being offered. Nothing indicates that this was being done strategically. Nothing's in the record indicates that this was somehow an effort to, surprise the people or create any prejudice. It was simply perhaps a misapprehension on counsel's part as to whether it constituted an alibi or information that was only recently learned by him. In either event, there's nothing egregious about that would warrant preclusion as opposed to a brief. I think the court indicated that the people would be entitled to a 3-day adjournment in order to.
If counsel was not aware, as he says, if he was not aware of this information until right before, the second trial, when there was, I believe, 4 months between the two trials, right?
Yes.
Then it seems to me that we need to know why, because the information certainly was available or should have been available to him. And that's information that's not on the record before us.
I think that what's in the record is sufficient to order a new trial. Certainly that question, if this court chooses not to, would certainly be the subject of a possible 440 motion.
Right. But you said there's enough on the record before us, so we don't have to go there.
I believe so, yes. Certainly from my vantage point, there is.
Okay.
Thank you.
Thank you.
Good morning.
Good morning.
If there ever was an egregious situation for a failure to file an alibi notice, this would be the case. The judge in this case used the word gamesmanship quite a bit in precluding alibi. And primarily that's because that first sexual assault is linked completely to the night his best friend, Ryan Gibbs, died. He was aware when he received the indictment, the day when the sexual conduct occurred. But giving defendant every benefit of the doubt, 4 months before this trial began, he heard the victim testify that the first time it ever happened was after Ryan Gibbs died. Now, whether it occurred at 9 o'clock, 10 o'clock, 11 o'clock is really of no moment. And I believe this is what the trial judge said. This is all about what happened that night. This is about the activity. Defendant was aware of it. He chose to stay silent. And I will leave this to the court's recollection, but I almost believe that there was either testimony that he was either living with his sister for a point in time while the case was pending, or there was some point, but I believe that there can be no doubt that there was a rapport between the defendant and his sister that would have not have prevented him.
Right, you would think that the defendant, Mr. Griffin may not have known that the defendant was allegedly picked up by his sister at 1 a.m., but the defendant knew it or should have known it. But
this is why this is so egregious. This is why the court precluded.
Right, but whether this is even alibi, I'm not sure that this testimony is even alibi. The crime allegedly, according to the victim, took place no later than 11 p.m. That was her testimony. I don't think she was looking at a watch or anything, but it was that night. But if we accept that time frame, which the defendant asked us to do, then being picked up at 1 a.m. is not inconsistent. He was still at the house when the crime was committed, so there's no alibi there. So it's either irrelevant, he was picked up at 1, which is after the crime occurred, which would mean it's irrelevant, or if it occurred during the crime, it's alibi and there was no notice. So it would seem that either way, he loses.
Exactly, Your Honor. And I believe, it was always on or about between 9 and 11 o'clock. So that is our position, and that the fact that, if it's not offered for alibi, it is irrelevant for these charges. If there are any questions, I'll rely on my brief.
Thank you. Okay, recalling 825, People versus Woodward.
Your Honor, she's not ready yet.
She's not ready yet? Okay.
Would you like us to let you know when she is ready?
Sure, thank you.
Okay, thanks.
827, People versus Haberfield, and 827.1.
Good morning again.
Good morning.
Greg Keem for defendant appellant. We assert that a hearing concerning paragraph 10 of the pre-sentence report is necessary. Defense counsel at sentencing objected to paragraph 10. And the allegations in it they're gross. She refused to change her underwear, refused to shower, took fully clothed showers.
Is there any evidence, Mr. Keem, that in the record that the court based its sentence on any of that?
There is not, but the pre-sentence report is so important that because these kind of allegations can follow her throughout the correctional process for years to come, that there should have been some kind of determination whether any of this was true.
Did she ask for a hearing?
She didn't ask for defense counsel didn't ask for a hearing specifically, but did object to the entirety of the paragraph. I think that really should have clued in the trial court to make some kind of determination as to whether or not that information was accurate.
Your worry is that this will hurt her if she goes before the parole board. They may look at the pre-sentence investigation.
Yeah, the parole board and then future pre-sentence reports. I mean, this is the kind of information that's salacious. It's memorable. It's the thing that someone who reads this will hold against a person. And when you look at the sentencing point, this is a person that has her associate's degree. When her mental health is in check, she's a person that helps society as a counselor, as she's done good things. And I think that having this kind of decided whether this is true or not, or whether to this extent is definitely detrimental to her future. Unless there are other questions on the brief, then I'll rely on it. Thank you.
Okay. Mr. Tonra?
Josh Tonra on behalf of the people. May it please the court. There was no request from the defendant for a hearing. There was no request for a pre-sentence conference. What it comes down to is a dispute in the pre-sentence investigation regarding the defendant's conduct while awaiting sentencing, and who is responsible for whether or not the defendant took a shower, and who is responsible for whether or not the defendant's toilet was flushed. It's not material to anything to do with the sentencing. And so I would submit to the court that there's no basis upon the dispute in the pre-sentence investigation to return the case, even if the court finds merit in the defendant's arguments with regard to the pre-sentence investigation. The appropriate remedy is not to vacate the conviction, but simply to return the case for potentially a hearing with regard to striking portions of the pre-sentence investigation.
Okay, thank you.
Thank you.
828, People versus Mills.
I'm not sure why I was, I'm not on this one. I'm not sure why my video was started.
Let's see. Okay, he's gone.
No, I'm here.
Oh, Mr. Ross.
I'm here.
Hey, you're here.
Slight technical problems, which seems to be the rule for the day.
Yeah, a couple. We're getting through it, though. You may proceed.
Good morning, Your Honors. May it please the court. Bill Rothschild on behalf of Donald Mills. First point I'd like to address is that the trial court improperly permitted the jury to examine Mr. Mills' driver's license during deliberations because, pure and simple, it was never admitted into evidence. Under CPL 31020, the jurors may take with them any exhibits received into evidence at trial. Items not in evidence are therefore not allowed because they have not undergone cross-examination.
Counsel?
Yes.
I thought that the whole wallet was in evidence.
Your Honor, pointing specifically to the record, page 623, the judge admitted, in fact, that the wallet was admitted into evidence and that the cash in the wallet was admitted as well, but the court specifically said that any other items were not allowed in for evidentiary purposes.
Thank you.
The reason for this was that during deliberations, the jury asked for the license. They asked if the license was valid or just a form of identification. We would submit that the court submitting that to them was in fact improper. The jurors asked for it because—
Mr. Rothschild, can I just interrupt you? So with respect to the last statement that you said, the court said that any other items in the wallet were not admitted for evidentiary purposes?
I believe so, Your Honor.
Limited to the wallet and the cash in the wallet specifically?
Yes.
Yeah, I don't get how this hurt your client. I understand the issue that your client claimed he couldn't read, and therefore the statement he didn't know what he was signing. But his testimony, if I'm not mistaken, was that the police officers verbally told him what to say. He repeated it verbally, and then they put it in a statement. So the question isn't whether his written statement is accurate. It's whether he was coerced because he had just verbally said those same statements. So I don't, even if there was an error there, if they believed him that he said the only reason he said it was because he repeated what the police said, then it would seem that the error would be harmless.
Well, Your Honor, as far as the statement being harmless, I mean, the question is whether whether it was coerced, and defendant's Mr. Mills' mental state was in fact extremely crucial to that. There was testimony, ample testimony that he had an IQ of 66. He had been in special education. He actually dropped out of school when he was 14. The people attempted to overcome this by introducing, hey, here's the letters that he wrote from jail. In fact, they weren't letters written by him at all. They also brought in another police officer to say, hey, he was an informant, except that police officer couldn't say that he was able to read or write. The reason this was so crucial is because the prosecutor was saying, hey, he's got a driver's license, therefore he's fully capable of doing this, because in order to get his driver's license, you have to be able to read and write. And that, in fact, was a false statement. It was untrue, and I would ask the court to take judicial notice of that, put that in the brief as far as what the requirements are. In fact, the person doesn't need to be able to read and write. People can have the test, in fact, administered to them orally, and it's crucial towards his capacity and his ability, which was the linchpin of the defense. We would submit that, in fact, while there was—
Are you talking about his capacity to waive Miranda rights?
That too, Your Honor. As far as also his capacity, they basically said he's the mastermind, essentially. Look at the money that we found in the wallet. Look at all this stuff. He's the mastermind of this. And there was a defense put in that not only did he lack the capacity, but also he was not the mastermind. He couldn't be the mastermind because essentially he was classified with an IQ of 66, which is, pardon the term, essentially mentally retarded. But they're posing him as this mastermind, and we would submit that was based upon the admission of that license, and whatever the license said. The problem was it wasn't cross-examined. There was no voir dire on it, and the prosecutor made the statement, hey, if you got a license, you can read and write. That was brought up for the first time on summation. So that's in my second point as far as prosecutorial misconduct. This basically goes in, it essentially establishes things which are not subject to cross-examination. It presents something to the jury where essentially they become unsworn witnesses, having quote unquote reviewed the license, which is essentially improper. It goes to a bedrock principle that we are supposed to determine solely upon the evidence admitted at trial. And this was never admitted at trial. Obviously, there was no objection to this, and I asked this court to review it both in the interest of justice and also because it was essentially ineffective assistance of counsel to fail to object to the statement of the prosecutor, which was, among other things, wrong, and also to the introduction of this license in the jury deliberations, which never should have gone in. If there's no other questions, I would otherwise rely upon the brief.
Okay, thank you. Mr. Orsler.
Morning, Your Honors. Brad Oster for the people. May it please the court. I'd submit that the license was actually submitted in evidence and it was reviewed properly by the jury on the basis of the fact that the wallet on its own is completely irrelevant to the case at hand. The fact that there was a wallet found in the apartment is of no moment. The officer's testimony, the officer who found the wallet, testified about using the license contained therein to further the investigation, identify defendant and allow prosecution. I think also importantly here, And I acknowledge that the court made a comment, I would submit somewhat in passing, and I guess I'm confused as to why the court said the contents were not admitted, especially given the subsequent act of allowing both parties to be heard and then allowing the jury to expressly view the license. It certainly seems as if the court did in fact find the license to be admitted. And I think it's important here to remember that neither party objected to the license being supplied to the jury.
Counselor, let me ask you a question. I don't want to put you on the spot, but on the record, defense counsel says that at page 623, it'll show us that the court did not allow it. Are you disputing that?
No, I'm not disputing what the court said. The court said something. I don't have the transcript right in front of me, but the court said something to the effect of the contents were not admitted. But the court followed up immediately thereafter by allowing the license to be viewed by the jury. The court said, hey, defense counsel, prosecutor, how do you want to resolve this jury note? The jury note specifically requesting whether or not it was a license or some other form of identification in the wallet. Both parties agreed that removing the wallet from the license and submitting it to the jury was the appropriate response. And obviously the court, on consent of the parties, allowed the license to be submitted to the jury.
Mr. Ofer, is the whole issue of the license a red herring in this situation?
I think it is, and that's sort of getting into I think what would be the defendant's second point about the prosecutorial misconduct on summation. The license was discussed in testimony simply for the fact of that being how the police identified defendant. Defendant, and on his direct case, brought up the idea that his cognition was below average or insufficient to allow him to waive Miranda. That's sort of a side point here, and the license was not introduced for that reason at all. On summation, the people responded, I think, properly to defendant's contention that his intelligence was so minimal, or that he didn't understand the Miranda waiver, by pointing out that, hey, if someone has a driver's license, there is some level of cognition that's inherent in being able to earn such a license. People did not introduce evidence. They were not, the thrust of their case was not about proving defendant's ability to earn a license, pass a test in whatever form it may have been. And the prosecutor, I don't think, went outside the bounds of what was reasonable in terms of discussing the mental capacity of obtaining a license. He just directed the jury's attention, I think, to their own common sense experience that, hey, if you have a driver's license, you certainly passed the test. There's some level of cognition or ability displayed therefrom. But I think, Justice, that you're correct, that's sort of, that's not a point that was important to the people's evidence. The people's evidence was that the police, on a warrant based on information from a confidential informant, went into the apartment, found drugs in a couple of different spots, some within an arm's length of defendant, and based on that evidence, the people's case is relatively strong. There's not much to assail.
Right. They found 450 individual doses of cocaine, but what I think the license was probative to, it was more probative to the fact that $1,041 found in the wallet belonged to the defendant because his license was in there. Is that correct?
It was related, certainly. The part of defendant's case was that he, I believe he received supplemental security income, and that his brother or another relative was essentially the receiver of those funds, or that money was going to be given by defendant to the relative.
Right. His claim was that he was illiterate. He was receiving SSI. His brother had to take care of his money, but then when the police come, they find a wallet with his driver's license in it, along with $1,041, would suggest that he's involved in drug trafficking.
Right.
And I think there was testimony that drug users don't have that kind of money.
Right.
They usually spend it. That would seem to be the relevance of the license, more so than whether he understood Miranda or whether he understood the statement that he signed.
I think you're correct, Your Honor, and to the extent that the defendant was acquitted of the sales charge and was only convicted on possession, it's rendered somewhat moot at this point, I would say. But in any event, I still would essentially rely on the points in our brief that the people's treatment on summation of the driver's license was not outside the bounds of what was allowed, and there was no error essentially committed there. Not to mention that it was unpreserved, as I mentioned. Unless there's any other questions, I'll rest on my brief.
Thank you.
Your Honor, we have 825 audio only.
Okay, recalling 825, People versus Woodward.
She's ready.
Ms. Hallenbeck?
Good morning, Your Honor.
Good morning.
Thank you for your patience with my technical difficulties.
Well, that's okay. You know, we're all on a little bit of a learning curve with this, so you may proceed.
Yes. Thank you. I'm appearing on behalf of the people.
Right.
The defense has submitted, and in light of that, I would rely on the arguments in our brief that there was not newly discovered evidence presented that would warrant a new trial in this matter. Unless there are any questions that you have, I will rely on the brief.
Okay, I hear no questions, so thank you very much.
All right, thank you.
Welcome. 829, People versus Shanley. Counsel, you may proceed.
All right, thank you. Good morning, Your Honors. Allison Kalbersbowski for Appellant Douglas Shanley, and may it please the court. So really two things. My client should have been permitted to at least make the motion to withdraw his plea when his attorney asked to, and thereafter, certain things happened on the record that should have put county court on notice that there may be something awry with this plea.
Can I just stop you there? Did you just say that the lawyer asked to withdraw the plea, or the client asked to withdraw the plea?
No, should
Yeah, so my client's final defense attorney requested that he have time to make the motion.
Yeah, he wanted to be adjourned, but he didn't actually make a motion.
That's correct. Yep.
Okay.
Yes. So the initial reason for asking to withdraw the plea through his last attorney had something to do with the fact that he claimed that he had been promised weekends. And perhaps on its face, that's not persuasive. But I'm not sure that we can be totally sure what would have been in that motion because defense counsel was not allowed to even make it. So one further adjournment probably would have harmed no one at that point.
Although there had already been, there was 11 months between the time of his plea and the date of the sentencing, right?
That's correct.
11 months had already passed.
Yes, and this case was sort of atypical for just a guilty plea because of the number of substitutions of counsel and also just the number of adjournments and trying to get restitution squared away. But even if we don't necessarily consider that an abuse of discretion, what followed after is that we do have my client making statements that amount to, if not a defense, sort of resembling a defense that should have at least put the court on notice that it should have inquired further into this plea. So
this is at sentencing, right? This is the statement he made or statements he made at sentencing, right?
In part. So at sentencing, yes, he says, you know, I was employed. The complainant contracted me to work on this house. And, you know, we had this relationship. I had permission to possess these materials, these buildings.
So your argument is that he made the equivalent of like a Lopez statement at sentencing. And so the duty to inquire that's imposed by Lopez at the time of the plea colloquy, you say, should also apply at sentencing. And I think you rely on People versus Pastor for that proposition, right?
Yes, that's correct. And that this sort of ongoing need to address issues that may crop up with a plea. And it isn't
Would
just.
you agree at sentencing that your client could have moved to withdraw his plea? He could have made an oral motion to withdraw the plea at that time, right?
Yes, he could have, but I think his attorney had just tried to. So I'm not sure it's fair to put it on him.
His lawyer didn't try to. His lawyer asked for an adjournment to do so. Justice Peredato is asking, all right, well, the case isn't adjourned. There could be an oral motion. The defendant himself could say, Judge, I want to withdraw my plea. I thought I was getting weekends. Or I moved to withdraw my plea. I didn't steal anything. I had permission. He didn't move at all, orally. He didn't need an adjournment.
I think that he was trusting his attorney to make those motions for him. And, even after this, though, we have even more statements that sort of bring it to the court's attention that there may be something else going on.
Well, let me ask you this. If the court under Lopez, if it applies to statements at sentencing here, the court's duty to inquire, where does that lead the court? So the defendant says, I didn't take them. I had permission. The court has to inquire and say, are you sure you didn't take them? And the guy says, no, I didn't take them. Then what? Does the court have to allow him to withdraw his plea even though he doesn't ask for that?
No, but I think we didn't even reach the threshold in this case because the court can listen to what the defendant says. And at that point, then he can make a decision. He can make a ruling. But because, the adjournment was asked for to make the motion and that was denied, we can't really say.
But what ruling was the court supposed to make? There's no motion to withdraw a plea. The defendant says something that calls into doubt his guilt. You say the court has to inquire at sentencing. Does the court then, if the defendant reiterates his innocence, does the court just sua sponte have to vacate the plea?
And I'm not trying to repeat myself, but I think that he has to at least listen to what is said and then in his discretion make that decision. I think it just depends on what he hears.
Yeah, I'm just having trouble putting the rationale of Lopez at sentencing. In Lopez, of course, if the defendant says something during the plea allocution that raises a doubt as to his innocence or the voluntariness, then the court should not accept the plea. The plea hasn't been entered yet. At sentencing, the plea's already entered. And at that point, a motion to withdraw can and should be made. So, now I agree with you. Pastor says what it says. I don't understand it. Doesn't seem to make sense to me. And I don't know what the duty to inquire, what purpose that would serve or where it would lead anybody.
Well, I think it would at least assure the court, the court is familiar with the defendant by this time. And if we consider not just what is said at sentencing, but even later, at the restitution hearing, we have statements made by the complainant that sort of call into question what happened here. And maybe not explicitly, but it certainly raises a flag. And so I think that where it would lead is that there's an interest in making sure that people are pleading to things that they did. And I think that the defendant.
But when we're talking about Lopez, we're talking about a very narrow exception to the preservation. I mean, we're talking about preservation here.
Yeah.
I think the courts always have an interest in making sure that there's a knowing and intelligent and voluntary plea. But what we're talking about is whether your client was obligated to move to withdraw the plea based on, or whether there was some sort of duty, whether there's some sort of Lopez duty to inquire at sentencing.
So I guess if I understand I think that the defendant is not required himself to make that motion. I think he should trust his attorney to make those motions for him.
Well, right. The obligation is on either, if defendant's pro se, he makes it, or his lawyer makes it. No, I don't disagree with that.
What remedy are you asking us for here? Do you want the plea vacated or it to be remitted so the court can inquire?
I think in this case, Your Honor, I'd be asking for the plea to be vacated.
All right, so if we were to do that, then would you agree that the defendant in this case, having made no motion is in a superior position than a defendant similarly situated who does make a motion. Because if a motion is made on these grounds, motion to withdraw the plea, probably going to be denied and we're probably going to affirm it. So we are rewarding a defendant for not bringing a motion. That doesn't seem right.
Yeah, and doesn't Lopez say it's just a, narrow exception to the preservation rule? So you'd be able to make the arguments that were on that record below that weren't inquired by the lower court, we would inquire. You wouldn't get, you wouldn't win, in other words, and your client wouldn't get his plea vacated. We would consider what was said below and do what the lower court didn't do. We would look at and decide whether or not it does attack or negate or otherwise make the plea, the plea was unknowing.
Yes, I would agree with that.
Anything further, counsel?
No, Your Honor.
Okay, thank you. Counsel.
Thank
may
you, Your
proceed.
Honors. May it please the court, Josh Sonner on behalf of the people. I understand where counsel is coming from, but asking this court to vacate a judgment of conviction based on a motion that wasn't made and no request to make that motion.
Well, let me ask you this. This is what we're struggling with. It seems that the Court of Appeals has said what they said relative to when this Lopez exception could apply. In other words, is it just at the plea or is it apply at sentencing too? And then, two things could happen in sentencing. You could make a motion, the defendant could make a motion, or they could, put some doubt into the plea and the court would have to do an inquiry. And if the court fails to do that, the question is does that narrow exception to the preservation rule that the defendant didn't avail him or herself of, can we get to it under Lopez if the discussions are at sentencing and not at plea?
Judge, I don't have the answer for that. I don't know how far it goes. I think, particularly in a case like this, if we even were to say, okay, it's preservation doesn't matter, they didn't have to make the motion. We have this statement that he made at sentencing. It requires us to take a look back at the plea minutes where the defendant's plea is unequivocal about both what he did and also the fact that there was no sentence promise. The people, it was myself as that attorney saying that we were going to be seeking a sentence of 2 consecutive local years with the remaining charges, that the court had not committed to any sentence but would entertain arguments for sentence if restitution were to be paid. No restitution was paid over 11 months while the defendant, through 3 different attorneys, sought to adjourn the matter for restitution. And in that intervening time, no mention is ever made about a sentence promise or an indication that the defendant pled guilty to something he didn't.
So your point is that even if we agree with the defendant that the motion didn't have to be made, if we address it, it has no merit.
Correct, Your Honor. I'd say, and it doesn't even require the court to agree with the defendant. Again, no motion was ever made. The defense counsel asked for an adjournment to explore the possibility of making such a motion.
Right. Now, if I'm not mistaken, there were 2 statements made at sentencing, not the restitution hearing, but at sentencing that raised Lopez concerns, we'll call them. One was the defendant saying he thought he was going to get weekends if he paid $30,000 in restitution. Is that what he said?
I don't remember the exact quote, but of some substance that sounds like accurate, right. Judge.
And, well, that is not an involuntary plea because he didn't pay a penny of restitution, did he?
Correct, Your Honor.
So even if that was his understanding, he was getting weekends if he paid restitution, he's not entitled to weekends because he didn't pay restitution.
Correct, Judge.
So that wouldn't seem on the surface to raise Lopez concerns. The second statement does seem to indicate he said he had permission to have the door. He was going to use his landlord's door to put it in somebody's house and so forth. That does that does negate an element of the theft, but it wasn't made during the plea colloquy.
Correct, Judge.
And it wouldn't seem to make sense to allow a defendant to get out of his plea just by claiming innocence at sentencing, standing alone.
Correct, Judge. And if the defendant had been able to make a motion to withdraw the plea, the court would have been left with, he makes this bald assertion at sentencing that's belied by the statements that he made under oath during a pretty thorough colloquy during the plea.
Let me ask you this, not to get you off your game. Let's assume that we read past Pastor to say that it can be done at sentencing. Lopez applies at sentencing, right? Let's leave the fact that he didn't make a motion on the side. So now what was said, as I understand the law, does that trigger the court's duty to inquire further, right? And so if he says that he didn't really take the property, I think it's hard to debate that it doesn't trigger the court's duty to inquire. And if the court doesn't inquire, all it gets him is to be able to challenge it here, an unpreserved claim. Now, we can't inquire, so what are we to do? Do we look at what he said compared to what your point was to the plea? Or do we say, what was missing here is the court didn't inquire, we can't inquire. Now, do we send it back down for the court to inquire? And then based upon the inquiry, you may be right. It's just not good enough. You were in this courtroom 6 weeks ago and, years ago, and you admitted to all these elements, and everything you said didn't negate an element of the crime denied. You understand? I know I'm rambling a little bit.
I understand your question, Judge.
What's the remedy if we agree that Lopez applies to comments made at sentencing?
Well, my understanding of the way that Lopez would work is that all that it would do is eliminate the requirement of preservation. And the court could then look and see if indeed the plea was knowing, voluntary, and intelligent.
Right, but every Lopez case that I could find, they're almost all at plea for a good reason. The remedy there is you vacate the plea. That's what we've done on every single Lopez case. We don't send it back on a statement made during plea for the court to inquire, because the whole idea is you're not supposed to accept the plea in the first place in the face of these types of statements. So it's just a confounding situation. Pastor is not consistent with what I understand the law to be. It's not consistent with what I think the law should be, but it is from the Court of Appeals, dicta though it may be, and that makes it kind of difficult for me.
Or is the answer that it depends on what the person says? If they give a mere conclusion and say, I didn't do it, maybe it's not triggered, because maybe we're caught up with what would the inquiry be?
Well, I think
I can follow up on Justice Carney real quick. I think it's a segue to what he's also asking, so I'm hoping it fits in. But looking exactly what the defendant said at the sentencing, let's assume that instead he said it at plea. And my ultimate question is, if he said this at the plea, would the court have had a duty to inquire under Lopez? What he said was, I understand that, I've done wrong things in the past, but as far as committing a crime of something that I was contracted to do and be in possession of something that I had permission to have and to plead guilty on was very hard for me to do. If he had said those words at plea, would the court, in your view, have been obligated to inquire further?
If his response had to the colloquy inquiry, either from myself or the court, did you steal this property? And his answer was, no, I did not steal the property. The court wouldn't accept the guilty plea.
Let's not change the facts. Okay.
I'm sorry, Judge.
No problem. But if he had said that, and I know I'm kind of asking you to switch gears here a little bit, but you didn't address People v. Pastor in your brief, to my recollection. So here is, if I understood the context, at least for me, if he had said those words at the plea, would it have triggered the duty to inquire further?
I think so, but And I believe, and I know we didn't address it, was Pastor within the scope of a motion to withdraw the guilty plea?
No.
At the time of sentencing?
That's what's interesting about Pastor. Even Judge Lindley said that the language in Pastor referencing the sentencing may be, in my view, it's dicta. Pastor dealt with comments that were in the PSR that perhaps after the plea was taken, that related to a possible justification defense. And so there was no issue before the court on Pastor relating to statements by the defendant made at sentencing. So, but there also was no motion to withdraw the plea.
Okay.
Now, there are
cited to Lopez.
Right.
Right, and there are third department cases that apply Pastor to statements made at sentencing.
Right.
There are cases now from other departments.
Yeah.
But again, I just don't understand where that Lopez inquiry is going to lead you at sentencing. And it would lead nowhere, I think. Perhaps best that could be said is that the court had a duty to advise the defendant that he has the opportunity and should file a motion to withdraw the plea. That would make sense to me. But in the absence of a motion, I don't know what else the court is supposed to do there.
And I think it's sort of getting away from, I think, the inquiry that we're talking about. But I mean, the court even asked, are you moving to withdraw the guilty plea? I mean, the court did give the defendant that opportunity and he didn't avail himself of it.
Well, maybe the Court of Appeals, maybe they were speaking of a different fact pattern that perhaps it might trigger Lopez, or Lopez may be applicable. In other words, if it's sentencing, the defendant says, wait, what are you talking about? I'm getting 2 years. You told me I was going to get 1 year. You know, maybe that's the inquiry that the Court of Appeals was talking about.
Sure.
When they were talking about the facts, such as negating an element of the plea, maybe you can't bring it up at sentencing. Maybe there's limited things you can raise at sentencing, and this type of claim, negating an element of the crime, must be brought up at the plea.
One last point that I think, and we've beaten this to death, but to preserve this claim, it's not just a motion to withdraw a plea, it's a motion to vacate the judgment, which can be done after sentencing, right?
Correct.
And there was no such motion here. So in other words, the defendant's lawyer asked for an adjournment to bring a motion. It was denied. I'm not sure that precluded him from thereafter filing a motion.
To vacate the sentence. Yeah.
Yes.
Vacate the judgment.
It wouldn't.
Right,
He
he
could
could
have
vacate
brought
the
that.
judgment. We always say there's two. You have to either motion to withdraw or motion to vacate the judgment. He didn't do either one. So it'd be tough logically for me to say this plea should be vacated when neither of those options was taken. But we have Pastor, which makes it a little more difficult.
Understood.
Anything further, counsel?
I don't think so.
Okay. All
Thanks
right.
very much.
Thank you. 831, Yaley versus Rich.
Your Honor, Mr. Sly is submitted.
Okay. Case is submitted. 832, Brockway versus the County of Chautauqua.
Morning, Your Honors.
Good morning.
May it please the court, Peter Veach for the defendant appellant, County of Chautauqua. And I'll be brief. I just have a few points. I think everything's pretty well set out in our papers. It's our position that the trial court got this one wrong, misapplied the prior written notice rule in this case, which arises out of a slip and fall on ice in a county-owned parking lot. First, I think it's undisputed that the plaintiff conceded the absence of prior written notice such that the county met its initial burden on its motion for summary judgment. Second, the only admissible evidence proffered by the plaintiff, his 50H testimony, demonstrates that he seeks to hold the county liable for mere passive failure or an omission to remove all snow and ice from the driveway at issue. This court's precedent specifically Glover versus Botsford, that's 109 AD 3D 1872, cited on page 24 of our brief, makes it clear that it's well settled the mere failure to remove all snow and ice from a sidewalk, a driveway, a parking lot, does not constitute affirmative negligence. It does not constitute the creation of a hazard. To that end.
So that's not enough. That's not enough to create an exception to the written notice requirement.
No, a mere passive omission to remove all snow and ice or salt or sand does not constitute an affirmative creation under the amiable exception. While we're discussing amiable, I think it's important to point out that the plaintiff also never included any allegation that the county derived a special benefit or made a special use from the parking lot driveway at issue. To this end, I think it's pretty clear that the submission is
Counselor, pardon me real quick. Your point, as I understand it, is there's no notice. We have a written notice statute. Our case law is clear. That's the ball game unless the plaintiff establishes an exception, and they clearly didn't do that in this record.
That's correct, Your Honor. And I think as an alternate point to that, it's pretty well briefed in our papers, the plaintiff should have been precluded from attempting to raise an affirmative creation exception in the first place, given the deficiencies in his notice of claim. He never set forth that theory of liability, and the first time it was raised was in opposition.
Let me just stop you perhaps while you're ahead. It's really, when you make a motion based on the absence of written notice, you're not really talking about theories of liability. You're talking about a condition precedent.
Absolutely.
Without written notice, the plaintiff the claimant or plaintiff doesn't get in the door.
Absolutely.
They try to raise a question of fact. If they do, for example, if there's a creation of a condition, that gets them in the door. We're not talking about the liability that may be in the case. We're talking about, do you even get in the door?
Correct.
And you say they didn't create a question of fact that gets them in the door, and that's the end of the story.
They didn't create a question of fact as to prior written notice, and they failed to raise a question of fact as to the affirmative creation exception. My point before was, even assuming they were allowed to raise the affirmative creation exception in opposition to the motion, the deficiencies in their notice of claim, the trial court should have precluded them from doing so.
Okay, thank you very much.
Thank you, Your Honors.
833, Meyer versus Simpson.
Good afternoon, Your Honor.
Good afternoon. I was just seeing who we have. Okay, go ahead.
May it please the court, Catherine Buckley on behalf of Dr. Simpson and Upstate Orthopedics. The crux of our argument on appeal is pretty simple. It's that plaintiff failed to establish a proper foundation for his expert, that his expert had sufficient qualifications.
Yeah, so you're not debating with victims.
Hold on, let me just hold you. Do we have Mr. Pizzullo on the line?
Your Honor, Tim Demore, I've taken over the case for Mr. Pizzullo.
Oh, okay. Okay, so it's just the two of you arguing? I have three people listed to argue.
No, Your Honor, Jeffrey Harris from the Sugarman Law Firm for Dr. Montgomery.
Oh, okay. I'm sorry. All right. I'm still getting used to this setup. All right, I'm sorry to interrupt you. Go right ahead.
Okay, so what you're arguing is you met your burden of proof, and you're not debating with Bickham versus Beer Wagon, which was a case I was reversed on when I was a trial judge. You're suggesting that it could, but it didn't happen here because there wasn't a proper foundation as to the plaintiff's training as it relates to orthopedic surgery.
Correct, Your Honor, and not just training, but experience. So plaintiff's expert basically gives two specific opinions where he says that Dr. Simpson deviated from the standard of care. The first is that he states that Dr. Simpson should have, during the 5-7 procedure, should have either examined the patient's arteries or called in vascular surgery to do so. He does not establish that he has any experience performing the washout and debridement procedure that Dr. Simpson was performing. He instead states that he has performed thousands of revascularization procedures. Dr. Simpson is not a vascular surgeon. Dr. Simpson is an orthopedic surgeon. He did not perform any revascularization procedure on this patient. Plaintiff's expert, Dr. Collier, also, he indicates that he would expect an orthopedic surgeon that he was working with to advise him of the findings that Dr. Simpson found. But he does not state that Dr. Simpson deviated from the standard of care in his communications with vascular surgery. Vascular surgery examined this patient and cleared him for surgery that same day and did not request to be in the surgery. So our argument here is that he did not establish that he had any experience with this surgery, that he had any experience performing this particular surgery, or even working with an orthopedic surgeon
Right, so
performing this
you're
particular surgery.
heading us off at the pass about weight. You're saying, could be, but under these circumstances, the proper foundation wasn't laid, and therefore it shouldn't be considered.
Correct.
Okay, I think we understand.
So the other opinion that he gave was that Dr. Simpson deviated from the standard of care in the neurological checks were somehow after the surgery were somehow improper, but he doesn't indicate how Dr. Simpson deviated from the standard of care. Did he fail to order those checks? Did he not order them frequently enough? He doesn't establish what the standard of care was, regardless of whether he's qualified to opine about Dr. Simpson's monitoring of this patient following the surgery.
So your argument is that his opinion wasn't specific enough, that it's conclusory?
In addition to the fact that he was not qualified to give opinions about an orthopedic surgeon monitoring a patient. Even if we could say that, okay, well, this is a vascular issue and he was qualified to opine about it, he didn't actually say how Dr. Simpson deviated from the standard of care in that instance. And otherwise, he makes a statement that there was immediate vascular compromise after the surgery, but does not say how Dr. Simpson may have deviated from the standard of care by not identifying it, whether he does not say that Dr. Simpson was even aware of the findings after the surgery.
Doesn't get into what the claim of any ischemic changes from 5.3 to 5.6.
Correct, yeah, there are no opinions prior to the 5.7 surgery.
Yeah, okay.
Plaintiffs could have submitted an orthopedic expert here and chose not to do so. There were two separate specialties making motions here. Plaintiff chose to oppose with only one expert and in our opinion, did not establish a proper foundation for his opinions about the orthopedic surgeon. If our motion is granted regarding this issue, plaintiff still has an avenue of relief against the vascular surgeon. Any other questions?
Hearing none, thank you.
Okay, thank you.
Well, you should know, stay at your seat. Stay where,
okay.
Oh, I'm sorry, he's gonna come argue, I'm sorry.
Well, Your Honor, would you like me to respond to her argument first?
Why don't we hear from we'll hear from the co-defendant first. And then you can respond to both.
Okay, thank you.
Counsel?
Good afternoon, Your Honors. May it please the court. Jeffrey Naris from the Sugarman Law Firm for Dr. Amankwa and University Surgical Associates. With regard to Dr. Amankwa's motion for a summary judgment, there are two specific areas that we look at with regard to the trial court's decision. First, there were 4 claims that Dr. Amankwa established definitively that he was entitled to summary judgment.
So in other words, your argument is what's good for the goose is good for the gander. You attack the theories of the causes of action contained in the bill of particulars, and you're saying you met your burden, and in response, the plaintiff didn't come forward through his expert and create a question of fact as to the 4 claims or theories related in the bill of particulars.
Correct, Your Honor.
Okay.
There were 4 specific claims enumerated in our brief. We specifically established summary judgment to them. One of them was actually a cause of action pled in the complaint to the lack of informed consent claim. And plaintiff's expert did not touch those claims in his opposition. At best, he made a blanket statement that says he, quote, totally disagreed with the statements of our expert, which we believe is...
Well, it was undisputed, wasn't this? This was talked to his mom and the child, the doctor did? Is this
Yeah, his mother and his girlfriend,
Yeah.
right? The doctor spoke to them about the possible consequences of this kind of injury and this kind of surgery.
Correct, Your Honor. But the other three claims we enumerate as well in terms of the improper procedure or improperly performing the popliteal bypass procedure, the monitoring for ischemic changes from May 3rd until noon on May 7th, and the failing.
Let me go through them quickly with you. One of the theories is in the bill of particulars that it was a negligently performed bypass.
Correct.
And plaintiff would say, look, we did create a question of fact, but we say that the defendant failed to monitor this condition after the bypass, and it's 6 in one and half a dozen in the other.
Your Honor, I think those are two separate theories. Performing the surgery properly and failing to monitor the patient post-operatively are two very different things. The surgery could have been performed correctly and a post-operative complication could have developed outside of whether the surgery was performed correctly or not. And that's why we believe the claim that the surgery itself was performed correctly, which plaintiff's expert did not respond to, should have been dismissed, and that if this were to go forward to trial, the claim should be limited to just those which plaintiff attempted to oppose.
Okay, let's move on to let me help you out here. The third claim is not being present, that they should have been present, right?
For the May 7th washout procedure, yes,
Right.
Your Honor.
And you say that, I guess what they would say is their expert says that this was best for a vascular team, and that gets them there.
And our response to that would be, it doesn't say that a vascular surgeon has to do this procedure. There's no indication that an orthopedic surgeon was not qualified to do this procedure, as Ms. Buckley said during her argument as well, that Dr. Simpson was more than qualified to do this procedure, and that nowhere does it say there's a deviation from the standard of care in Dr. Amankwa not being present for the surgery. It's in the bill of particulars, but it's not in the expert affidavit. And
And then the last one is this issue that the plaintiff expert didn't really attack the claims of any changes, relative to the decreased blood flow from May 3rd to May 6th. In other words, there was no ischemic changes.
Correct, Your Honor. And I think that's even in plaintiff's expert affidavit. He says he does not ever state there is ischemia until May 7th at noon. He believes there's ischemic changes, which leads me to our second point, that the whole foundation for the two opinions plaintiff's expert did render is this belief that there is ischemia. However, he doesn't establish that there is ischemia. This is an improper foundation for his further opinions. It's speculation, it's conclusory, and in fact, his support for why there could have been ischemia on May 7th is contradicted by the medical records.
Yeah, your total issue with that is that the real contention is it's unsupported by this assumption that he utilizes.
Correct, Your Honor. The opinions themselves, which I can address a little later, are speculative in and of themselves, but they also are based on an improper foundation. This belief that there was ischemia at this point in time, which is not documented. And again, the plaintiff's
Your position is it wasn't documented until noon on May 7th.
Your Honor, our position is that at noon on May 7th, the documentation directly contradicts what plaintiff's expert puts in his affidavit, that there was modeling of the toes, that there was lack of perfusion. The note by Dr. Amankwa on the 7th directly contradicts that. So plaintiff's expert's statements that there was ischemic changes aren't founded in the medical records, and that's an improper foundation which would render that opinion speculative and conclusory.
What does it matter that there's some proof on this record that the plaintiff was feverish, had fevers prior to the 7th?
Your Honor, fevers are a very non-specific finding, as our expert noted, and that wasn't a specific ischemic change, that the ischemic changes in the lack of flow, which are what plaintiff's expert claims Dr. Amankwa should have been looking for through these objective tests, those ischemic changes are not present at the time Dr. Amankwa last sees the patient. And that also helps transition to the second opinion the plaintiff's expert rendered, which was a blanket statement that Dr. Amankwa is basically the improperly deferred to orthopedic surgery, and that he should have been consistently on the case. That's nothing more than just a blanket statement. There's no facts to support it. He doesn't follow up with stating why Dr. Amankwa should have continued to monitor the patient, why Dr. Amankwa was deferring to orthopedic service at that time was improper.
Well, his position is that his specialty, because of his specialty, he should have stayed. He should have been kind of the primary person on the case, right? Because he was the vascular specialist.
That is his position, Your Honor, but then the expert fails to follow it up with relating it in any way causally to how this would have resulted in a different
Yeah,
outcome
your
for this
argument
patient.
is he doesn't explain how the deviation caused the loss of the leg, but he did say if he performed the objective test, he would have been allowed to treat then and there, but you say, but he doesn't finish up with, and then the leg would have been saved, or the leg would not have been lost.
Or he doesn't go on to say what treatments would have been available. It's one thing to say that there's a causal relationship, but the requirement is the plaintiff has to explain what that relationship is, what tests could have been available. I believe there are 2 third department cases that I cite, Longtemps and Gallagher, in my brief, both of which are very similar facts here, where the plaintiff's expert says tests should have been done or studies should have been done, but then says they caused the injury, but doesn't go on to elaborate how failing to do those things caused the injury. In both cases, the third department found that those opinions were speculative and conclusory and insufficient to raise a tribal issue of fact. And we believe those decisions are informative with regard to what is going on in this case. And then lastly, I just want to point, the plaintiff created a new theory of liability in his brief. His responding brief puts forth a third theory of liability to Dr. Amankwa, that he was responsible somehow for Dr. Simpson and was vicariously liable for Dr. Simpson. We would ask the court not consider that, as it was never pled in the bill of particulars. It was never a part of the summary judgment motion, and therefore was improper to raise before the court at the appellate level.
Okay.
The court has no further questions. I'll remain the rest of my brief.
Thank you.
Thank you, Your Honors. Tim DeMore, may it please the court. I guess I'll start with addressing the first argument as it relates to the vascular surgeon and whether or not our expert has the authority to render an opinion on the standard of care. I would suggest to you that under the Deal versus Byron case that this court had back in 2008, that he is capable of doing so.
Yeah, I think we can get past that issue.
Okay. And then as it relates to whether or not a vascular surgeon should be the person overseeing the vascular issues or the orthopedic surgeon. In this case, you have a vascular surgeon who transferred his care to the orthopedic surgeon to oversee those services.
Yeah, in other words, you can't have it both ways.
Exactly. You can't pass it one way and say, he's going to take over the care for here, but yet we can't render an opinion back this way. So I wanted to point that out. As it relates to the vascular surgeon, what I think our expert clearly spells out is that Dr. Amankwa relied on subjective testing. There was never specifically an arteriogram ever done. He failed to participate in the debridement, and he passed those duties off to the orthopedic surgeon. And while during that 3-day period or 4-day period from the 3rd, when the original surgery was done, to the 7th, when the debridement was done, there's clearly evidence in the record that there is a debilitating or a worsening of his prognosis. And so it is our position that there is certainly questions of fact as to whether or not the orthopedic surgeon and the vascular surgeon properly oversaw the care and treatment during that time period and after the 7th, after the debridement, such that if they had caught it sooner, they could have.
Yeah, I may have misunderstood one of their arguments. I think their real contention, I'm not sure, looking at my notes, there's a lot of issues here, is that the assumptions, there's assumptions and they're not supported, that in other words, that there was any ischemia or any changes there from during the period of May 3rd through the 6th. Now at noon on the 7th, maybe what his argument was they had proof that there were no changes.
Well,
I thought that's when it first really said, your suggestion is just based on his presentment.
Yes.
That gets you there. In other words, there was some, loss of feeling, there was some coldness, the toe, I think
Yes.
the toe was cold.
Cold to the touch, pulse, yeah.
And so that's enough factually to get you there that your opinions are not assumptions, but based upon fact.
Absolutely, Your Honor. Based on, that's exactly what our argument is as it relates to questions of fact. That's what we're here about. Are there questions of fact? Let's let a jury decide whether those specific symptoms are enough that these physicians should have taken some action. And I'd further say to you, during the course of the debridement on the 7th and the abundance of necrotic muscle that was found is almost like a Monday morning quarterback saying, boom, there's the proof that there was a process going on and
There must have been decreased blood flow.
Absolutely.
Yeah, I got you.
Mr. Demore, let me take you to the argument that they made in their brief for the vascular surgeon.
Okay.
At pages 18 to 21. And as I understand the argument, is that you essentially conceded or abandoned certain claims when your expert did not address them in his or her affidavit in opposition. I'm not sure you addressed that in your answering brief, respondent's brief, but is that what we should be doing? Do you contest that? Do you agree with that? Should they have moved for partial summary judgment? Should they have moved for relief under 3212G? I mean, how do we address that?
That's a good question, Your Honor. And as you know, I took over this case about a month ago, so I actually didn't author either of the briefs. That being said, if there's specific claims that were addressed and those claims were not contradicted on respondent's brief, then I suppose they are considered by law abandoned. But they're not the issues that we're really focused in on. We're focused in on.
You know which Ford we're talking about?
Specifically, I don't.
I just happen to have my screen, so I have an advantage.
Okay.
Number one, lack of informed consent. Number two, failing to be present during the May 7, 2014 procedure. Number three, and this is from page 21 of the brief, improperly performing the polyteal, I mispronounced it, bypass. And four, failing to diagnose ischemic changes from May 3 to May 7 at noon. So it's rather particularized statements.
If I may, the first thing in the informed consent, I think there was informed consent. So the record is clear to me, and that's not a claim that even if we were to survive or summary judgment that we would be pursuing a trial. So that to me is a non-factor. However, the failure to diagnose the ischemic changes over the period of May 3rd to 7th, as I was discussing with Judge Carney, I think that's really at the heart of the claim here. So we're certainly not abandoning that claim.
And your expert did address it, you would say?
I do. I think he addressed it in his affidavit very clearly, specifically talking about what the changes were and if they had been diagnosed or recognized, that his leg would have been saved. He not only addresses it, he's talking.
In other words, your theory is it was negligent because they failed to monitor it.
That's correct.
Right. And then your next theory was not being present, and your expert says, well, look, this was best for the whole vascular team. They should have been there.
Absolutely.
And that's that's the third and the fourth one relative to the ischemic changes. I guess you've sort of addressed that relative to telltale signs that maybe there wasn't a particular test done, but the presentment of certain symptoms gets you at least foundationally to get it to the jury.
That's correct, Your Honor. That's the important part here is we're looking to get it in front of a jury.
Thank you, counsel.
Thank you very much.
834, Solvay Bank versus Fair Rubbish Removal. Justice Carney is recused.
Are we all set?
Almost. Okay, she's all set. Mr. Carroll, you may
Thank you.
proceed.
The issue of the priority of payment in a receivership, the state of New York would appear to have a sovereign right to a priority.
That's really the only issue that is before us on this appeal right now.
That, as far as I'm concerned, yes, Your Honor.
Yes, so that New York has a preference for their sales tax and the other debts above the other unsecured creditors, right?
That's correct, in the proper order of priority.
Right.
I think they're third, either after administrative costs and other such things like that.
So the problem I have with that contention is that that specific point was not raised before the motion court.
I raised 1210, Your Honor, generally. And I
But you never
discovered
mentioned section 507, for example.
No, I argued it, I believe I argued that, most of that in a general way, Your Honor.
Right.
Mostly BCL 1210 is what I argued.
Right.
And they have a section in there that covers sales, that covers taxes and sales taxes. And I was relying mostly on the fact that the sales tax would be covered under 1210. And in further research after that, I did indeed discover this sovereign right to priority. And I thought I should, I decided to add it in.
No, the state doesn't seem to have a problem with its place in line.
What, Your Honor?
You can correct me if I'm wrong, but the state of New York hasn't objected to the priorities given here.
They haven't, the Attorney General hasn't even appeared. Labor's here and they objected and got their money. But the Attorney General, who would be the one who would assert the sovereign right, never appeared in the proceeding. I don't even know if he was notified.
So the question for me is, you concede that this specific issue was not raised below. So the question is whether we should address it or not.
That I leave up to you, Your Honor.
Okay.
But I would point out that that the sales tax is held in trust under BCL 1210, and I rose that at every level.
Okay, thank you.
Thank you.
Ms. Bennett.
Good afternoon, Your Honor. Teresa Bennett, may it please the court. I think that Justice Perodato identified the real issue here, and that is that none of the issues raised by the appellants was raised below. And so now, even with respect to, for example, the section 507A8 claim, we don't have enough information in the record to even determine whether these sales taxes are entitled to a preference under bankruptcy law. In order to be entitled to the preference, it's not sufficient that they simply filed a lien after the receivership was commenced. They're required.
Yeah, there's a timing element.
There's
to
a timing
507,
element to
right.
it, and all we know from the record is that the sales tax lien is a result of an audit from September of 2014 to May of 2017. There's no distinction about whether those claims were in 2017 and 2014, and if so, how much? How much is entitled to a preference? The other issue is that although the appellants appear to acknowledge that only the sales taxes are entitled to a preference under 507A8, they've also asserted that the DEC claims and the Department of Labor claims and the Department of Transportation.
Yeah, there are a number of other New York debts.
Right,
Correct.
and so then in our reply brief, once we've raised all of these issues, now we've got yet another general claim that the state is entitled to a preference under sovereign immunity. Well, the state also has the right to waive that preference, and as Justice Lindley has already identified, the state has not asserted any claim of priority here.
Right, so if we're considering whether to reach these issues, these unpreserved issues in the interest of justice, a factor might be whether the party who's being hurt here, the state, has any problem with what's going on, and it doesn't appear that they do.
That's correct, Your Honor, and I would also state that it's unclear from the papers what preference the appellants are asking for. So sometimes they say, we're entitled to $875,000. Well, if that were true, then other secured claims apparently have less priority than these state tax claims. Well, I think the other secured creditors would like to be heard on that issue. They've already been paid pursuant to Supreme Court's order, and I would submit that they would assert that they are absolutely entitled to priority over the state tax claims.
Okay, thank you, counsel.
Thank you, Your Honor.
Your Honor, if I might add.
No, we don't permit rebuttal in this court. Thank you.
Your Honor.
835, Tozan versus Engert.
Good afternoon, Your Honors.
Okay.
I think we're set?
I think we're set. Yes,
Okay.
you may. Yeah.
Good
thank you.
afternoon again. There are two issues before the court. The first is
I'm sorry to interrupt you, but let me get right to it for you. How's that?
Okay.
Looks like the court's decision used a couple different standards, and your point is they used the wrong standard.
Correct.
And, I found it a little bit odd because I didn't think we used this language too often, but apparently with legal sufficiency, we use the word utterly irrational.
Yes.
But with weight, we use palpably irrational. But it was further compounded by the language we usually use. It appears that the court used the sufficiency and not the weight. And you say that when we do examine it under the right standard, that it was against the weight.
Exactly, Your Honor. That irrationality, whether it's irrationality, it's like infinity. There's more than one kind of infinity mathematically. But for us lay people, if it's infinite, it's infinite. If it's irrational, it's irrational. Whether that's palpable irrationality or utter irrationality. The standard for weight of the evidence is more generous than that. So the court looks at everything and says, this doesn't compute. It's not fair. There were things that were overlooked.
Right, so there's a lower burden for weight. If I understand you correctly in your brief, there's a lower burden for weight.
Correct.
Because the remedy is less harsh. You just give someone a new trial. Sufficiency is a higher burden because if they win, it's a judgment.
It's exactly what the Court of Appeals said in Cohen, and they've been adhering to that ever since.
And you're arguing weight here.
Yes, we're arguing weight.
So you want a new trial. But what I don't understand is, okay, you get a new trial, and then the proof comes in again. Unless you win, you'll be right back here. It's going to be against the weight of the again. We're just going to keep sending it back and back and back. So until you win, isn't that right?
I do not think so, Your Honor.
Unless the proof changes.
What?
Unless the evidence changes at any retrial.
By that argument, there would be never any reason to have another trial on weight of the evidence grounds.
Yeah, that's my point, yeah.
That's kind of gets to a kind of infinite regress argument about an infinite regress danger. And in fact, we have a kind of built-in safeguard against that, and that it just becomes too costly to do that anyway.
Right.
Well, let me ask you this, getting into the merits of it, there's no dispute that the plaintiff had some prior injuries and some degenerative problems. It's sort of, your weight argument sort of flows into what the experts base their opinions on. And your point is that she actually did complain, because it seemed about when she complained about this ridiculous symptoms, whether it was immediately after the collision or it was a couple of days later or a couple of weeks later. And you're saying that the proof showed that she actually did complain immediately, and that's why it's against the weight.
I'll build on that if that's all right with you.
Go ahead.
The ridiculous symptoms here are very specific, and they're on one side only, and they emerge a few days after the accident. I think both experts agreed that radiculopathy does not develop the moment of trauma. It takes a few days to develop. And our argument is she was reporting that by April 9th. And her reports are consistent with the exception of that one day on April 20th, when she said she didn't have radiating pain. Now, we can explain that. Dr. Pilcher has explained that as you have good days and bad days.
And she was on some pain medication already.
That's right. The defendant fixates on that and then has to explain away everything else. And their explanations are not grounded in the evidence. For instance, they say the April 9th report of radicular pain doesn't count because back in October of 2014, she had had an injury and she complained of radicular pain. But as we showed in our reply brief, the records from October 2014 say that she was suffering from shoulder and arm and hip pain. There was nothing going down into her leg. So that argument falls down. The argument about the degenerative conditions doesn't explain why it is that a bilateral degenerative condition would come up with unilateral symptoms on one side. And it also depends on this, it's the usual, I hate to say it, defendant's argument that it's just coincidence that there was an accident at the same time the degenerative conditions kicked in. Here they will admit that Ms. Tozan suffered injuries as a result of the accident. But they say, well, the injuries got better. But as the injuries are getting better, her degenerative condition was getting worse.
I don't, all of that may be true. One of the problems that I have is it would have been very helpful, however, that if the plaintiff's expert had actually reviewed the pre-accident medical records that came out. And so a lot of what you're explaining could have been better explained, or perhaps explained without the possibility of attack, if your client's expert had reviewed her pre-accident medical records.
I think in a way,
because the defendant's expert says, look, this is the normal progression of degenerative stenosis, or, and this seems a little like speculation to me, but another event subsequent to the collision. And he says, hey, look, these things would have presented themselves, this radicular pain would have presented probably immediately or within 24 hours. And so, to Justice Peridato's point, you got to have it all there, and you got to be able to take on that. And isn't this just a classic battle of the expert?
It is. I think we've pointed out to the points where the facts here don't support Dr. Castellani's argument. It is not a classic battle of the experts. And as this court said in the Grant White versus Hornbarger case, just because there are experts on both sides doesn't remove the right to review for weight of the evidence. And where opinion testimony is contradicted by the facts must prevail. I think this, in a way, answers Justice Lindley's question, which is that when you look at the record as a whole, which is what is required in reviewing for weight of the evidence, it appears that the jury did not interpret the evidence in a way that was fair, and that on a retrial, the jury would be presented with the evidence perhaps more persuasively, perhaps with the knowledge that this was what had been missed before, and we would expect a result that does comport with the evidence. We don't think that this result did.
Is it possible that the jurors may not have credited your client's testimony as to her physical condition before this subject accident? In other words, she claims to have been running miles on the beaches and everything was fine. After this accident, shortly thereafter, she really struggled. She couldn't do much. Is it possible that they just didn't believe her testimony about her pre-accident condition? Is that a basis to look at how they reached the verdict?
I can't speculate about what the jury did or did not believe, but I don't think there's a shred of evidence in the record that suggests that my client was not telling the truth when she spoke about being essentially physically fine up until the accident.
Because she had a prior back surgery.
Yes.
And then after that, she had another motor vehicle accident. And then she had this one.
And the third one was the charm. The first two she recovered from. And Dr. Pilcher did have, he was familiar with that at least. And he agreed that this was the cause of her radicular pain on one side, which has left her, to this day, pretty incapacitated.
Right.
Okay, thank you, counsel. Ms. Gardner.
Good afternoon, Your Honors. Laura Gardner appearing for the defendant respondent. Well, I do appreciate all the arguments as far as which legal standard should be applied. The one thing I'd like to point out in that respect is that Judge Frazee, in her decision from January 25th, 2019, did apply the standard that plaintiff asks for. And although she did include language from what plaintiff opposes as a different standard, she specifically held that the evidence did not so preponderate in favor of the plaintiff that it could not have been reached on any fair interpretation of the evidence. That's the exact standard.
There was a motion to re-argue too.
Correct.
Even though that wasn't granted, and that's not before us, she did, she did clarify that she was applying the correct standard.
Exactly, Your Honor. So she went back and she applied the fair interpretation standard, which is exactly what plaintiff sought at the time, and it's what plaintiff seeks on appeal now. And to say that Judge Frazee never exercised her discretion in that respect is just in contradiction to her decision from January 25th.
Yes, to this is, as I read the brief, I know there's a lot of medicine and there's a lot of facts about what doctors in this, the plaintiff seems to have some past problems. There's no disagreement. It's undisputed that there was a degenerative condition. And really, it seems to me that this case was really, or at least the argument is made that she really didn't, whether she complained about these radicular symptoms, and, immediately after the accident or later. And that was the basis of, it appears, both experts, or the battle of the experts. And I guess your argument is there is information for the jury to adopt and for the expert to adopt that is consistent with not complaining immediately after the collision.
That's exactly right, Your Honor. There's substantial evidence in the record that led the jury to make the decision it made.
Amadio or one of the plaintiff's doctor did a nerve study on the 15th, which is 9 days after.
Correct.
And that there was nothing wrong. And then on the 20th, which is maybe 11 days, do I got the dates right? Dr. Pilcher, which was 2 weeks after said that there was no report of any of this pain that we're talking about, this radicular thing.
Exactly, Your Honor. And that's the crux of the arguments Dr. Castellani made as far as defending his conclusions, that Dr. Pilcher, to come to a different conclusion, had to completely disregard a note from his own office as to whether the plaintiff had symptoms 2 weeks after the accident. And both doctors agreed that in a case of acute trauma, acute nerve damage, she would have had pain much sooner than the 14 days the April 20th note represented. Now, in addition to that, Dr. Pilcher admitted that plaintiff's pre-existing conditions could have conceivably progressed regardless of this accident. And so Dr. Pilcher made way for Dr. Castellani's opinion, where he said that her symptoms that developed a month and a half after this accident represented a natural progression of her pre-existing condition. The jury very likely looked at Dr. Castellani's basis for his opinion, as well as Dr. Pilcher's admission that Dr. Castellani's opinion was possible, and came to the conclusion that Dr. Castellani's testimony was simply more credible in this case.
Anything further, counsel?
Nothing further, Your Honors.
Thank you. 836 and 837, Smiley versus the State of New York. Okay, Mr. Martocha.
Hello, Anthony Martocha for the claimant appellant. As this court knows, comparative fault is an affirmative defense that must be proven by the defendant. Here in this instance, the defendant failed to meet that burden. There's no facts in this record that the claimant did anything negligent. While it's unclear what the lower court, what the reasoning the lower court for a 50% liability decision against the claimant was, it seems that the court hung their hat on the fact that the claimant wasn't looking down as he was walking. That decision or that ruling by the court is misguided if that's in fact what was the determination for their ruling. If you look at the cases that that I cited and the defendant cited in this case, they both stand for the proposition that not looking down does not create fault unless the condition was readily apparent.
Right, most of those cases are supermarket cases, and there's some sauce spilled on the floor that you might have seen. This was not that type of case, and it looked like the judge found comparative negligence based on walking briskly, failing to see what was there to be seen, failure to use the floor mats, and he was looking forward at his girlfriend. I guess his girlfriend had pulled up at the front of the hospital, and he was looking at his girlfriend. So now I agree with you. There's nothing inherently negligent about looking forward where you're going when you're walking. Matter of fact, it's probably safer than looking down. You're going to run into something. But what about walking briskly? Is there anything to that?
I would say no. It wasn't like he was running towards the door. He was walking in a manner that briskly, I guess, is what the word everybody was using. But he wasn't running. He wasn't doing anything out of the ordinary. Walking briskly alone isn't negligent.
I think it would be negligent if you have reason to know the floor is slippery.
Right.
But here it doesn't appear. I've looked at those photographs, the enlarged ones, very carefully. I can't tell from the naked eye that the floor is wet. It looks clean, no doubt. There's some shine from the lights, but it doesn't look wet. So I'm not sure walking briskly on a dry floor would be negligent. What the state argues on appeal, it seems to be focused on the sign, the warning sign. The court didn't appear to rely on that. Could you tell us where exactly, there was one sign, if I'm not mistaken, where exactly was it on his path?
It was at the exit. So if he was walking into the hospital, I'm sure you're familiar, Judge Carney, with the hospital. As you're walking in those revolving doors, the sign was placed there. He came out of the elevator, there was no sign. So
there was no sign outside the elevator, and the sign that was placed was, at least at that time, not necessarily visible to him.
Correct. And that was people coming in to the hospital, not going out of the hospital from the elevators. So quite I think they said 15 to 20 feet, but I think it's probably more as far as the distance from where he fell to where that sign was. Typically, if you're going to put a wet floor sign up, you would put it in front of the area rather than behind the area.
And it seemed like there was a lot of foot traffic, and if the sign was toward the door in front of him, he hadn't passed it yet, it would not be clear that that's something he could see if people are walking. This appeared to be a shift in time where workers are coming and going.
Correct.
But the court didn't find anything on the sign. The state's arguing on it.
All right.
But I tend to agree with you. I can't identify exactly what this guy did wrong, and it seems kind of harsh to find any comparative negligence, let alone 50-50.
Yeah, I would agree. And you mentioned one or two things that I wanted to talk about quickly, if I could. One of them being he wasn't walking on the mats. If you look in the record on page 145 to 146, the judge just pretty much disregarded any testimony about whether he was walking on the mat or not. Saying what's the difference, or saying that it's immaterial. We know he wasn't walking on the mat. He wasn't required to walk on the mat.
Right, it's in June. The water didn't come from outside.
Right.
There'd be no reason to think that you have to walk on the mat.
Sure.
It was December.
Okay.
Right? The accident happened in December, didn't it?
Correct, December 17th, I believe, or 27th. I'm sorry.
The photo must have been taken later.
Yeah.
Yeah.
The photo's dated June of.
I think the photo was taken just prior to the liability trial.
Okay.
But we
So
do
it was an actual day of the accident.
know, we do know, don't we, that the water was not tracked in from outside.
Right.
It was from the maintenance worker cleaning it with a machine.
Correct. And I think what's key about the water is both the only people who saw it or who testified as to the condition were the claimant himself, who said, I didn't see it until I fell and I didn't notice it. And it was a smooth coat of water across the floor. The security guard who witnessed the accident also said the same thing, didn't notice the water until after the fall, until after he went over to help the claimant. At that point, he said the water was a very, very, he said twice, very, very fine coat. So certainly not something that was readily apparent, at least not to the security guard or to my client, the only two people who testified.
And this issue is worth $1.28 million. That's what the court deducted from damages based on him walking briskly and looking forward. So it's a big issue. There's a lot at stake on this one.
Correct.
Anything further, counsel?
No, Your Honor, thank you.
Okay, thank you.
Good afternoon, Your Honor. Good afternoon, Your Honors, and may it please the court, Sarah Rosenbluth for the state of New York. A fair interpretation of the evidence amply supports the trial court's apportionment of liability here. It's undisputed that the state did warn of the wet condition of the floor by placing a sign near the front entrance to the lobby. And it's undisputed, similarly, that Mr. Smiley was looking at that front entrance at the time of the fall because he recalled.
Does the record support a conclusion that he was able to see that sign as he was exiting?
Yes, Your Honor. John Stalker, the security guard, testified that when he went over to help the claimant after the fall, the sign was in the line of sight from where he was standing at the time. So there is evidence in the record to support the determination.
So it was in the line of sight from the area where he fell.
Correct. And so if he was approaching that area where he fell, he should have seen it. And this court's case in Johnson versus State is on point here, where this court affirmatively modified a judgment to apportion 50% liability to a decedent, where there was a sign posted warning of a danger, and the court specifically noted that it didn't really matter whether he didn't see it or whether he ignored it. He was essentially bound to see what proper use of his senses would have revealed.
Okay, so let's follow up on that. Let's assume he could actually see a sign that was warning him that there was some sort of a danger. Your opponent says the proof as to what the floor actually looked like didn't reveal much in terms of a danger, saying that the water was a thin film or something along those lines.
Sure. However, we do have testimony from the claimant that directly after his fall, he looked down and did see a smooth coat of water on the floor. So it's not like it was totally invisible. He saw it. The security guard saw it as well.
On the floor, it's probably more visible than when you're standing up.
Sure. The record isn't clear as to where he was standing when he noticed it. Both the security guard, I don't think the security guard ever, sat down on the floor. He, I presume, was standing when he went over to assist Mr. Smiley, and he noticed it as well. To be sure, it was not, a colored, very highly visible, very outstanding kind of spill, but it was visible, and the sign was there in his line of sight.
What you're saying is, and this is what the trial court said, he was negligent in, quote, failing to look at the floor as he was walking. And you seem to be saying the same thing. If he had been looking down at the floor, he would have noticed that it was wet. But that seems to be contrary to your prior argument about the sign, is that he should have been looking, he could have seen the sign in the distance.
Yeah, I understand, Your Honor. I mean, certainly.
He's got to look down at the ground, which is like either way, he's negligent.
Well, to clarify, I think that it basically behooved him to notice what was there to be seen, which was the sign. And if he had seen the sign, it would have put him on notice that the floor, in fact, was wet, and he should have looked down to kind of be careful and proceed with caution. And I'm not saying that, someone should be walking, looking down at the floor the entire time as they walk.
Your point is that he should have seen the sign, and the sign then should have drawn his attention to the ground, and he should have, in your view, based on the evidence, seen what was there to be seen and perhaps not been walking as briskly, right?
Correct. And so if he had seen what was there to be seen, which was the sign, he would have perhaps walked less quickly, looked down, seen the wet spots on the floor, which he did, of course, see later, as did the security guard. And so the sign should have put him on notice that there was a dangerous condition, and then he would have proceeded with more caution than he did. Certainly, the state did not put the sign near the elevator, and we did not challenge the finding on appeal that the state was 50% liable. But as between putting one sign instead of two, and having a condition that was apparent and that we know from the record was indeed noticed after, sort of too late, I think the 50% finding makes sense here.
I'm sorry, but do we know if it was noticed with the same foot traffic as the time that the claimant fell? In other words, were there people, if there's nobody in the hallway and you can see it, that's one thing. But if there's people in front of the claimant while he's walking at the end of the shift, then it might not have been visible. Do we know the answer to that?
I don't think we know the exact traffic in the vicinity when he looked down and noticed the wet spot. However, we do know that at that time it was busy in the lobby, and there's a lot of people leaving at the end of the shift to go home. And at the time when the security guard came to assist him, it was visible for both of them to see. And presumably the foot traffic pattern was not very different at that time compared to the original time, right before the fall. I think it was, in general, at the end of the day, there was a lot of people in the lobby, and it was pretty similar, I think, is a reasonable inference. And so based on the fact that we know that the sign warning of the dangerous condition was in his line of sight, based on the fact that he did not take notice of the sign to look down at what would have been apparent had he done so, based on not only his testimony, but also a third party, then there's an amply fair interpretation of the evidence that supports apportioning liability here.
All right, last question, at least from me. If we agree with you that there was evidence of comparative negligence, but we don't think it was 50-50, can we adjust that, or do we have to keep what we have 50-50 or go to 0-100? Is there somewhere in between? Do we have authority to do that?
I think that your cases do suggest that you can make an adjustment here. Certainly in the Johnston case, the court did make an adjustment. So I think the court can do that here. But the cases do support a 50-50 apportionment. The Johnson case was 50-50. The other cases we cite were basically a range of 40 to 70% liability for the claimant. So to the extent that there is an adjustment that would be warranted, it would be in the same ballpark. And 50-50, I think, is basically a reasonable way to split the baby on the facts of this case. If there are no further questions, I will rest on the brief.
Thank you.
Thank you.
838, 839, Rennert versus Rennert. Okay. Mr. Van Loon?
Nathan Van Loon for the appellant Mordecai Renner. Judges, this is your honor, and may it please the court. This is a two-pronged appeal. First prong is about religion and the importance it is for children. And this
You're
is
talking about the custody. The first, we've got custody determination and then determinations on applications for contempt. Those are the two issues before us.
Yes, Your Honor. With regard to the
Would it
contempt.
be fair to say, Counselor, that we should conclude that at a minimum, there was a change of circumstances warranting the review? That's not in dispute, correct?
It's not in dispute.
Okay. And then would it also be fair to say that the court gave us a close look, given the detailed decision and findings of fact we have?
They did give a look, Judge. to give a look. We disagree with the conclusion to that look, and we believe that the overlooking of the religious component, the sincerely held religious beliefs of the children was part and parcel of the error of the court. And we believe that, we proved that portion of the case, that these are sincerely held religious beliefs of the children, and that the children acted on their own based upon those beliefs. And the children throughout their entire lives have been raised in
What
a certain
evidence
way.
is there in the record, if any, that the father would promote the relationship with the mother in light of those religious differences that were held not just by the children, as you say, but also by the father? So is there any evidence in this record that the father would have promoted a good relationship with the mother?
Well, I think that the record shows that on numerous times, he did try and promote a relationship with the mother. He certainly encouraged them to go. He didn't say, no, you can't go. He, at one point, put them in a lift to go when they were refusing to go. And there have been numerous incidences in the record of where Mrs. Renner basically was gone for 7 months at a time. So it's really difficult to function as a parent when the other parent at certain junctures in the case either disappears or sort of negates their own authority by not being present. I don't think there was any indicia in the record of if mom called that he said, don't talk to your mom. There was no indicia in the record if she wanted to drop by and visit the children that he said absolutely not. There's none of that. What you have instead is you have these children acting in a way that they're making their own determinations in their own judgment, a kosher household versus no non-kosher household.
Sorry to interrupt again, but do you find it troubling for your position where the court that heard all this testimony after all these days and heard numerous motions beforehand, et cetera, or during, the court said, the court is certain that mother is the only parent willing to encourage and foster a relationship with the other?
I am troubled by that, but I'm troubled by that because I believe it's an error. I believe that that's not necessarily supported by the record. And I have to say this, is that there were a lot of joint decisions that were being made during the course of the marriage and even during the course of this custodial fight, so to speak, including keeping the children in religious schools, having the children go to the doctors, keeping everybody informed of the dental situation,
Counsel,
all these sorts of
let me
elements.
ask you this. Has there been a subsequent modification proceeding filed?
Not that I'm aware of. And my understanding is that there have been further court proceedings, and I am not involved in those particular proceedings.
What further court proceedings, Counsel?
But I think that they went back to court to try and resolve some of the differences that all the children are now out of state.
Yeah,
as
I
mentioned.
know, but you're using, what do you mean there are differences? Is it a modification of the custody? Is it another contempt proceeding? What type of proceeding needs to be resolved? Is there anything pending?
I think that there's a post-matrimonial on the custody that has been pending, and it just sort of has languished.
And it hasn't been resolved?
It has not.
Right, it looks
Let me
like,
ask you, go ahead. I'm just going to switch gears to contempt.
let me just follow up on what Justice Carney was talking about. Mr. Muldoon has asked us to consider things that have happened since this appeal was filed. And he refers to an order reinforcing a prior custody order entered in September of 19. The order appealed from is from February. And it looked like they had an agreement, and it was signed by the parties, and it was signed by the same judge who issued the order here. And it clarifies the kids are going to go to school and to a religious school in Philadelphia. The father's going to have this visitation. The father can't contact them from 7 a.m. Doesn't that order, I think Mr. Muldoon's arguing that this subsequent order renders moot your appeal. Have you, I don't know if you're representing Mr. Renner at the time, but are you familiar with that order?
I'm familiar that they made an arrangement to try and get the children in school, and that arrangement with regard to the children has been modified even after that. You've got one child in New Jersey. You've got 4 other children in Cleveland, Ohio.
But has the custody, but even in that subsequent order, and I don't know what, if there's an additional subsequent order, then that if it affects this appeal, that's something we should know about. But the subsequent order of which we are aware, it seems to me that the custody portion of that subsequent order remained unmodified. Is that correct?
That's correct.
It
All right.
Is anything changed? Are the kids living with dad right now?
The children are with there's one child who's in New Jersey with
Right.
paternal family members, and there are 3 children who are under the age of 18 that are in Cleveland, Ohio with my client and his family members. And there's one child that's aged out and looks like she'll be going to Israel.
So in other words, 3 of the kids are living with dad right now.
3 of the kids are directly living with dad and dad's family in Ohio.
So this order, the September order, this is outdated because it says the kids are going to go to school in Philadelphia and the father's going to have visitation, pick the kids up there, and the maternal grandmother's going to have visitations. They're not in school in Philadelphia anymore. So this is an outdated order itself.
Yes, it is.
Or it's not being followed. I mean, something's very strange.
Is there a new order?
There is not.
There's not a order that lays out this Cleveland issue?
No.
Okay.
So if I'm understanding correctly, if we were to reverse or modify in any respect based on your appeal, it would make no difference to the lives of these children, correct?
Well, I mean, the underlying order from Judge
Just to the
Donofrio
lives
gives
of the
sole
children.
custody to Dara Renner. So the facts on the ground is that Mr. Renner is taking care of the children and taking care of most of their medical and their dental and has got them enrolled in their schools.
And he doesn't need our help to do it.
Well, Mrs. Renner, I understand, signed the registration forms for schools in Cleveland as well. So it's not as if she's completely cut out of the process.
Take us, if you would, please, to the contempt applications. You would basically say it's a jurisdictional defect, and at a minimum, once the court gave the mother an opportunity to refile, amend, that the jurisdictional defect remained and you were entitled to a dismissal on that basis alone.
Yes.
Let me ask you this, was it refiled and was it served?
It certainly was refiled and we certainly did receive it, and then we answered, and so the answer to that would be yes. So that we received it. The issue at that point, however, was that there were actually 5
No, I know that.
motions.
Let me sort of.
Yep.
Because I'm a little confused. I'm more concerned about the 3 petitions. The first one that went along with the petition for modification, first order to show cause for contempt. And then there were 2 subsequent ones, as I understand it. That's what I'm concerned about. That related to a temporary order during that custody trial, that there were 2 subsequent ones, October of 17 and November of 17.
Right.
So is it true that when the hearing was had on the contempt, I guess the second hearing, not the custody hearing, that refiled paper of the order to show cause was really just, it sort of included those 3 petitions or those 3 former orders to show cause, as well as the 2 other ones you made reference to.
So what happened?
So it was a subsequent superseding document.
Right, with all the same allegations in the exact same manner, in the exact same way.
Let me ask you this, why was there so much concern about whether the first contempt order to show cause was going to be tried? And there was at least some indication that the lawyers thought it wasn't, because it already was tried when the custody was tried.
Well, that was part of the whole problem in the case, is that we didn't know what we were trying, so to speak.
Mm-hmm.
So, or we're trying the custody case or trying the contempt case at the same time.
Right.
How are we handling it? And there's other issues that are brought up, which are, what are the standards of proof? Is it going to be civil contempt? Is it going to be criminal contempt? What is it going to be?
It appeared to me that what was being tried was the first order to show cause was tried already. And when the judge bifurcated it, she bifurcated the 2 that flowed from the temporary orders of protection or temporary custody orders. But then when you went to court to try those 2, it looks like they said, well, let's try them all.
That might.
The judge did say that,
Yeah.
The 2, you and your opponent raised the question about, are we doing all 3 of these orders all these contempt petitions, or has the one from 2016 already been covered? Is that already been covered in the custody trial? And as I read the record, the court said, I think the safer course is to add it. So So all three of the amended petitions were part of the second trial, right?
Right, but all three of the amended petitions still didn't have the correct statutory.
Well, right, that's right. Once we get past the procedural, then yes, that's your point. Your point is, even though she was allowed to amend, it still was defective.
Yes, Your Honor.
So what did she do? Just like, in other words, amend the cover sheet and attach the old orders to show causes?
Yes,
Okay, thank you.
And then she got it wrong again.
yes, I would have to say, yes.
Okay, I think we have that argument.
Thank you, Your Honor.
Okay, Ms. Renner, we've given you time to argue. You may
Thank you.
proceed.
Thank you. My name is Dara Elizabeth Rennert. Being pro se and having a whirlwind of thoughts and emotions, I prepared a statement of my thoughts so that I can speak in an organized fashion.
Excuse you.
I welcome any questions or comments during my speech. I'm here today begging for the court's compassion and action. Confident you have reviewed the long litigious history in this case. Every single order, whether by mutual consent or court decree, has given me custody of the kids, and always, just always, Mordecai has refused to allow me to have our children, requiring me to jump through hoops and to meet his conditions. With regard to point 1, the court emphatically considered and weighed the religious beliefs of the children. Mr. Van Lood weighed heavily throughout the trial on the practice of Judaism and his client's perception of my lack of practice of Judaism. Faith, however, was never discussed. Faith being the essence of a religion. Judaism, maybe even religions overall, isn't as rudimentary as a few acts of practice. The depths of faith and practice in our respective relationships with God is truly unique. Religion was used by Mordecai as a sword over and over and over again. Mordecai used his lies, his perceptions to alienate me from the kids and from the Jewish Orthodox community, even having gone so far as to have me excommunicated in 2016 by a Jewish court in Brooklyn. His intention for every single move he made was to remove me from the kids.
Ms. Renner, could I, a lot of what you're saying is consistent with what the trial court said in its decision, and we've read the record. Have you, the children are in Ohio with their father now.
Yes.
The order that is being appealed from awards you primary custody, sole custody. Have you consented to an order that allows the children to go to Ohio with their father?
Never.
Is there any order that provides for that?
No.
Well, it looked like you consented to an order that provided for the children to go to Philadelphia to school there.
Yes.
And what happened to that?
Mordecai will not allow them to go to Philadelphia. Mordecai moved them to Lakewood, New Jersey, to 2 houses in Lakewood, New Jersey, and then moved them back here to Rochester due to COVID, and then moved them to Cleveland.
So he violated, in your view, the subsequent order from September of 19.
Correct.
And where do you live right now, ma'am?
I'm sorry?
And where do you reside right now?
I'm in Brighton.
Okay, thank you.
Did you file contempt proceedings to with respect to violation of the September 19 order?
I have not, no.
Is there anything pending, custody or otherwise here between the parties?
My understanding is that the only thing that is pending was Judge Donofrio had given, I would call what is like a last-ditch effort to allow Mordecai more time to comply with orders. And we were supposed to have a 6-month trial period for the kids to go to school in Philadelphia and then revisit at a 6-month point back to her court to see when, to see how it was going. But that 6-month point put us in the middle of COVID. So my understanding is that those issues of contempt are still pending.
With Judge Donofrio.
With Judge Donofrio. But that's my understanding.
So you won here, you won custody, but that hasn't played out on the ground.
Correct.
Do you have any visitation at all?
No. I'm heading into my 7th year of Jewish holiday seasons without being able to celebrate with my own children.
Would you like to address the contempt petitions? We have read the record and we've got, I think the panel has a pretty good handle on the contempt petitions, but I'll allow you to address them if you would like.
Thank you. I mean, I had written this all out and it had kind of merged my thoughts and feelings towards both custody and the contempt.
Altogether in kind of one statement.
Because they are extremely intertwined. And
sure they
Well,
are.
let me help you out, ma'am. Let's, if you can answer these questions, because some of them are legal procedural questions. But it's my understanding that this was commenced initially by way of a modification of custody and also a contempt proceeding. It was one order to show cause.
Yes.
Is that your understanding?
In
Initially.
December of 2016.
Oh, yes.
Yeah, and then there were two more that you brought against, that there was a violation of these temporary orders, because this custody trial went on for quite a long time, didn't it?
Yes.
And then the judge gave you an opportunity to do a refiling at some time.
Yes.
When you refiled it, what you did was you attached the old orders to show causes, and that was the thrust of your refiling, or was it?
Yeah, so from what I recollect, Mr. Van Loon had challenged saying that the cover and the wording was not.
It was defective.
Yes.
It's jurisdictionally defective, right.
And so that
So
Judge
you're
Chanfrio had wanted everyone to err on the side of caution.
Right.
And so she had Maureen change the language on the cover. Only the cover was changed.
Okay.
And then refiled.
And then you served it on gave it to,
Well, Maureen did, yeah.
yeah,
Right.
okay, great. I
And then-
understand, thank you.
Okay, all right.
Were you ever paid the $30,000 attorney's fees with respect to the contempt finding?
Never,
Paid anything out of that?
never, no.
Is there anything else you would like to add? I think we have a pretty good handle on your position.
Thank you.
Okay,
I have nothing more to add. Thank you.
okay. Thank you. Mr. Muldoon, so we'll have you, Ms. Renner, we'll have you step away so we can wipe down the table and then we'll hear from Mr. Muldoon.
May it please the court, Gary Muldoon for the children. There are 2 points in this appeal, and on the
custody issue is moot, right, Mr. Muldoon? It must be. If the children are in Cleveland and they're New Jersey, things have happened since. I mean, no matter what we do, it's not going to impact what happens, correct?
Your Honor, yeah, there was a previous motion that was made, I believe, by Mr. Van Loon, and in response to it, I had sent to the court a copy of an order that is not part of this record on appeal as such, but I believe the court can take judicial notice. I did so as an officer of the court in order to provide the court with some context of what was going on.
But the custody
that perhaps
order.
could affect the issue of mootness. I'm sorry?
So the custody portion of the order that is before us was not changed by the order that you submitted to us. So I'm not so sure we read that subsequent order as there being a relinquishment of the right to appeal the custody portion of the appeal.
And is that your position?
Your Honor,
You have a position.
I don't have a position on that. Your Honor, frankly, as the children's attorney, as AFC, it is my obligation to argue, and I am arguing that the order in this case should be reversed and that the children should be allowed to live with the father. That is the unanimous opinion, the beliefs of the 4 children who are still minors, all of whom are all of whom are teenagers, one turning 13 next month.
Mr. Muldoon, I'm sorry to interrupt you again, but following up on Justice Peridano's point, assuming that order doesn't change anything with respect to custody and leaves it reviewable by us, I'm more concerned with what we heard this afternoon about what's happened since then and whether or not those events have rendered this appeal moot. Do you have a position on that?
The children's position, Your Honor, is that they wish to live with the father and to be, have him act as their guardian rather than the mother. That is consistent with their beliefs, and
That's the position you're arguing to us today.
yes, Your Honor, that is something that just within the past 4 or 5 days, when I was in contact with children,
Do you
they
know if there's any
repeated that to me.
Do you know if there's any modifications of the custody, any petitions pending now in any state?
No, there is not.
Okay.
No, the last one was the one that I provided to the court. There is nothing pending in New Jersey. There's nothing pending where one of the children, Seema, is living, or in Ohio, where the 3 other minor children are residing.
So the order you provided to us is the operative custody order.
As best I know, yes, Your Honor.
Okay.
Okay.
So Mr. Van Loon's position in this matter has largely been that there is a religious influence that is important in the children's lives. I would suggest to the court that the children's belief is that, yes, they are very devout Orthodox Jews. But aside from that, they have fundamental differences with the mother's method of raising the children, their disciplining of them, as well as her lifestyle, such that they are not going to sleep overnight at their house. They will visit the mother, and they have visited with the mother on many occasions. But they're not going to do more than that.
When's the last time there was visitation with the mother by any of the children?
I believe they have had contact approximately within the past month. During the COVID time, certainly they have.
Contact or visitation?
I'm sorry?
Contact or visitation? When you say contact, I mean, that could be telephone contact.
I believe that when they were in the Rochester area, and which is during the COVID time, that they have had face-to-face contact with the mother. Not just telephone contact, but they also have had telephone contact with the mother, certainly. And I know that the mother has had contact, for example, with Seema regarding Seema's own difficulties. Seema's the one who is living in New Jersey with the father's relatives. So all of the children, whether they're living in Cleveland with the father or living with the in New Jersey, they are under the father's aegis, his supervision.
Doesn't the father, we have an order from Judge Donafield, right or wrong, from February 7, 2019. And it does not appear that the father is following that. And he's with the children now in Ohio. Under the order as it stands, they're not supposed to be with him, primarily supposed to be with the mother. And I know that there's subsequent things that have happened subsequent to the appeal here, but it would seem that it would be on the father to bring a motion to modify. And he hasn't done that. He just seems to be ignoring the order rather than bringing a motion to modify. And I think that that causes some concerns, at least with me.
Yeah, because even you put forth that you want us to consider at least some facts that took place from the original order. There's a lot that's happened from the appealable order till today, hasn't there?
An astonishing amount, Your Honor, including the 4 younger children having been expelled from their school, moving to New Jersey, all sorts of things that have happened that are almost extraordinary. And now the children are largely living in Ohio, where the father lives as well. So all of those things
together.
Yes, yes. With the younger child, with the mother, with the father's sister, I believe it is. So there are extraordinary changes that have occurred that, in my addendum to the court, as an officer of the court, I'm bringing this to the court's attention. However, the children are insistent, and I would say adamant, that they wish to live with the father and that to follow his, including his religious precepts. And that's a sincerely held belief.
I think we have that point.
Yes, very good.
Okay, thank you.
Thank you.
Case 840, Watertown Professional Firefighters Association versus the City of Watertown. Sure. Okay, I think we have everybody. Mr. Lambright?
Yes, Nat Lambright for Local 191. May it please the court, I have a few points I'd like to make on each of the issues that we're talking about in terms of the out-of-title dispute here. The first with respect to the municipal training officer, or the MTO position. The MTO position provides for training for all fire department personnel. This would be firefighters, captains, and battalion chiefs. Civil Service Law 61 prohibits, on a strict sense, except on an emergency basis, out-of-title work being performed. And with respect to the MTO, the captain's position, it's clear in the record with the civil service job spec, the captain only should be providing training to his or her subordinates. That would be the firefighters themselves. With respect to the battalion chief position, the battalion chief position provides training to all members of the fire department. As such, with respect to the MTO, which provides all training to all members of the department, putting that position with a subordinate, a captain, to provide training to a superior clearly is out of title. It's not a natural or reasonable extension of the captain's position to be providing training to his superiors and to other folks within his same rank when the civil service job spec says they should be providing training only to their subordinates. The lower court and the city has argued that this is an issue of them removing a battalion chief position, and therefore, because that position is no longer extant, the out-of-title case cannot be dealt with by this court. But the fact of the matter is, the city only abolished one battalion chief position. There still remains 4 other battalion chief positions. The other point the city makes, and that the court suggests, the lower court argued, was that because the city had changed its standard operating procedures, the city was entitled to essentially have the MTO, the captain, perform battalion chief work. If that was the case, I would submit then it would basically make the whole statute irrelevant, because all a city or an employer would have to do would be to change their internal standard operating procedures to authorize out-of-title work. It doesn't work that way. You can't circumvent the civil service law by changing internal procedures. With respect to the city's appeal of the holding by the lower court, which granted the petition that the captains performing, the firefighters working in the rescue vehicles in the right front seat of that were working out of title, I would submit that you had lengthy litigation going back to 2016. The record demonstrates that we had 2 arbitration awards by 2 highly regarded arbitrators, one who's actually on the PERB board now, and the other who was the director of conciliation for PERB. Both found that the city was operating the right-hand seat, these firefighters operating in a way that they were working out of title. The city has hence from that agreed. They didn't move to overturn with this court, Supreme Court's confirmation of one of those agreements.
Let me interrupt you there, and I apologize, and ask you a question. How did we find you folks here under this current procedural place? In other words, it was brought by an Article 78, and then I guess everybody realized that was the wrong procedure, so you consented to convert it to a declaratory judgment action. Is that true?
That is true. That was done at oral argument.
Right. Okay. So what would be the standard of review for us then under that, under a declaratory judgment proceeding?
I don't want to give an opinion on something I'm not sure about, Your Honor.
Okay. So in other words, but everybody recognizes it's a different, obviously it's a different perspective. In other words, the judge was making the decision in the first instance, not reviewing what somebody else did, other than it seems like he incorporated the view of the arbitrator, which was a separate proceeding and was separately confirmed.
I would submit, Your Honor, that what the judge did is he looked at the two arbitration decisions and gave them res judicata effect. And the Court of Appeals has held that arbitration decisions can be given res judicata effect.
Okay, I understand. Yeah, thank you.
Okay. Just a final point on this out of title issue. Your Honor, the city has argued that there's been some changes in the internal standard operating procedures, which would somehow perhaps invalidate those two arbitration decisions. The fact is, if you look at the arbitration decisions, the arbitrators solely based their decisions on not administrative duties that the right front seat of the rescue vehicle firefighters were performing, but the actual operational duties. So the fact that the city has added 2 or 3 administrative duties would in no way, shape or form change the arbitrator's award with respect to the operational duties that the firefighters perform. And I would just say again, if you look at page 224 of the record, which shows that change that the city relies on, the fact of the matter is the city acknowledges that 90% of the time when that rescue vehicle is operating, it is operating with those firefighters working out of title. And as a result of that, they are paying those firefighters every day out of title pay. And as the statute says, it prohibits out of title pay on a permanent basis, unless it's on a permanent basis, period. This is not an emergency with respect to the firefighters performing captain's work. It's an everyday occurrence in Watertown, New York. And it's been going on since 2016. And the city has abided by the 2 arbitration awards, and they're paying those folks out of title pay. So unless there's any other questions, I'll rely on my papers.
I just have one question because I don't have it in front of me. The decision and order, what was the rationale for the MTO or the captains and battalion chief? What was it was the last line of his decision. What did he base that on again? Because I thought that flowed into your argument. In other words, how the city changed the procedures. I was under the understanding all positions were eliminated, but you're saying.
No. Right. The judge does suggest that because the battalion chief position was abolished through a budgetary line, that this work couldn't be performed. And first of all, I don't think that's correct. The cases are, they would have to either not perform the work or they would have to actually hire someone to do the work. But in this case, they wouldn't have to do either because there are 4 other battalion chiefs who are currently in charge of the department.
Okay, because in other words, your position is, or my understanding of the law is just by eliminating the position doesn't get you around the civil service law.
No. If that was the case, again, you could just get rid of higher titles, and those titles the out of title statute would be meaningless.
Yeah, well, okay, thank you.
Thank you, counsel.
Thank you.
Mr. Sly?
Good afternoon. May it please the court. Robert Sly for the city of Watertown. I would like to address the MTO position first, and that's because the out-of-title work applies when someone's performing the duties of the higher title on a frequent and long-term basis. And what we have here is the fire chief submitted an affidavit below. He was the MTO for years. And what he says is that it's a unique position. It's not necessarily, it's very different from either a battalion chief spot or a captain spot. And our point is this is an administrative position appointed by the fire chief. It's not a civil service position appointed by the appointing authority. This is just who's going to train. That's all it is. And it does not invoke battalion chief responsibilities. Battalion fire chief, they're called. Usually battalion fire chiefs fight fires. This is a training position only. And this captain is performing those duties, and he's able to perform them. He's able to train, and as the fire chief with his years of experience was able to explain, he's able to do it. So this is not invoking the issue. What really is being argued in the brief of the fire union is that traditionally it's been a fire battalion chief position and should stay so. Well, tradition doesn't govern. What governs is whether this is a civil service position being filled by someone outside or below, or whether it's just an administrative position being appointed by the fire chief. So that's our position with regard to the NTO. We think the judge had it exactly correct, Your Honor.
And are there still 4 battalion chiefs? Only one chief was a battalion chief was eliminated?
That's correct.
Okay, thank you.
Yeah. And that was done upon the retirement of the battalion chief. So we didn't eliminate, we didn't fire anybody. Now, with regard to the right-hand front seat of the fire truck, of the rescue truck, the issue here is whether simply being assigned at the beginning of a shift to ride shotgun in a truck allows you to be paid out of title. The argument's made by the union that, well, the chief issued this department staffing and operations memorandum that changed duties. Darn right he did. Darn right he did. He said, look, you're not responsible for training the people on the truck. You're not responsible for the maintenance of the truck. You're not responsible for anything dealing with a truck except when it rolls, which is exactly what the Curry decision said, that when it rolls, they can be paid out of title. But if it doesn't roll, they have no responsibilities they have no such responsibilities for the other persons on the truck or for the truck. They're not performing captain duties. So,
but when it does roll, they are.
That's correct. When it does roll and they're in charge at the scene, they are. The memorandum is very clear that if a captain shows up on the scene, that the captain's in charge.
And that's, you would say that's an emergency.
Well, I have to acknowledge our argument on that being an emergency is not the emergency called for under the statute. I acknowledge that.
Thank you.
That's all we have.
Okay. Thank you.
I have one last question. You agree that you folks decided to convert this from an Article 78 to a declaratory judgment action?
I agreed to it in oral argument because I knew it had been brought in the wrong context and I wanted it to proceed.
Right. Otherwise, you'd be starting from scratch.
You're starting from scratch, and I think the judge had the right to declare, in connection certainly with the MTO, that everything was appropriate.
Okay. Thank you, counsel.
Thank you. Thank you. Good to see you, Nat.
840.1 in the matter of Tracy Vetrano versus the New York State Board of Elections et al. Judge Carney and Judge Lindley are both recused, and Justice Winslow is appearing remotely. And we're waiting just for Mr. Burns. Okay, there he is. Good afternoon, Mr. Burns.
Good afternoon. Joseph Burns for the appellant objector, Michael Palmisano. This case, for the most part, comes down to a single signature, that of Kathy Roan. The lower court, of course, validated that signature.
You say it was an alteration that can't be cured or rehabilitated. And the lower court really kind of really decided this on a credibility, on the basis of Stevens's credibilities. It's either a stray pen mark or it's an alteration, and the lower court decided that it was a stray pen mark. It seems based on the court's belief in Stevens's testimony.
That's certainly what the lower court found. I would say though to that, had there was an opportunity, there had been an opportunity for Ms. Stevens, the witness, to clarify that, had that been what in fact it was, that it wasn't an alteration. I point to you the April 9th, 2020 affidavit that Ms. Stevens signed. That's pages 78 and 79 of the record, where she states nothing about how it was merely a stray pen mark and not an alteration. I would also state that Ms. Stevens, the witness, is no stranger to this process. She's been circulating petitions, as she testified to, for over 40 years, including 10 years obtaining Working Families Party petitions. She's an attorney, a former candidate for public office, and a former county election commissioner. If she thought that there was any issue when this petition was submitted, she could have very easily initialed the alteration, or even in her affidavit from the 9th of April, she could have stated that it was a stray pen mark and not, in fact, an alteration. She never took either of those opportunities to provide that explanation. It's certainly somebody of her background, of her knowledge. I would have expected to. Mr. Burns? That, yes, Your Honor. But all that credibility determination, really, we should leave to the Supreme Court, because if it had gone the other way, you'd be telling us, wouldn't you, that, well, wait a second, the court heard the testimony, we should allow credibility determinations to be deferred to below. It's an abuse of discretion standard. Isn't your argument really that it was wrong for the court to conduct a hearing?
That's correct. I mean, the date in the signer's line is a matter of prescribed content under 6130 of the election law. And because this is a matter of prescribed content, it can't be rehabilitated. It's very similar to the town city issue that I believe I spoke to in the cited in the Canary decision. If I, as a resident of the town of Amherst, write that my town is Buffalo, I cannot then rehabilitate that signature through my testimony in Supreme Court. This is the same issue.
Is the New York State Board's determination that this was an alteration, is that binding on the court?
No, I wouldn't say that it's completely binding, but I would say there was never any attempt before the State Board of Elections to rehabilitate this signature by the candidate.
The court must play a role, right? That is a something. And is the court's role simply to choose whether or not to have a hearing and then make a decision based on that proof? Or is the court both supposed to just say, well, the board said so, so I have to adopt it? I'm having trouble with what the role is of the court here.
No, there are certainly issues in this petition process that a court could make a determination on. Certainly issues of fraud, for instance. Certainly issues of the let's say a board of elections failed to invalidate a signature because someone was enrolled in the wrong party. But for these matters of prescribed content under 6130, the opportunity to revive that signature, the opportunity to validate that signature,
it's not at the Supreme Court. It is before the board. And I would also say, much like the. Excuse me again, but does the court have the discretion to hear proof on whether it's an alteration? And is that discretion then governed by an abuse of discretion standard at our level? I would say that in a matter like this, much like the DeBernardis case. Now, in that case, there was no, but it's the same issue, I think, as you would find here, that the lower court should have deferred certainly to the Board of Elections decision.
Let me just ask you, can I ask you one question about something you said earlier? You said based on Stevens's experience, her extensive experience, passing petitions and whatnot, that she had every opportunity to explain this or initial it. If it's truly an alteration, even if she initials it, that doesn't cure the problem. If it's an alteration, it's an alteration, and it's disregarded, right? It can't be rehabilitated, even with her initialing, right?
Well, I would say had she initialed, had she made the initial, said this number has gone from a 3 to a 4. Right. I got the wrong date, as we all sometimes do. I crossed it out. I changed the date from a 3 to a 4, and I initialed it. Perfectly fine. We wouldn't be here. The signature, the board of elections would have found that it's perfectly fine. That is exactly what she should have done back in March. I would also add, and I did have this in my brief, that if in fact you find that the signature should have been validated, you may still invalidate additional signatures and should invalidate additional signatures, namely the ones found on pages 5, 6, and 7.
Well, the problem with what I see with that, though, is that the hearing was limited just to these 3 signatures. And there was no objection made at the hearing that the hearing should cover more. I know you raised issues with these other signatures, but at the hearing was limited to the 3 signatures. We don't have any hearing testimony with respect to the other signatures.
I would just say to that, I don't think that any testimony or hearing was even needed to invalidate those signatures. Because those signatures on 5, 6, and 7, or specifically the witness statement, had been objected to by my client, by Mr. Palmisano, and it was also raised in our answer. I don't think a hearing was even necessary for the court to conclude that those signatures should have been invalidated due to the fact that there was that the town and county of the witness was not properly stated in the witness statement, which would leave all the signatures on those pages invalid, and certainly leave the candidate, Ms. Matrano, with far fewer signatures than is required.
So you say that's why that you didn't challenge the hearing officer's determination to just limit the hearing to the 3?
When you say the hearing officer, do you mean the hearing officer before the State Board of Elections?
The court. No, I'm sorry, the court. I meant the court's decision.
Oh, again, I don't think simply based on the face of the petition, I don't think a hearing was even necessary. The petition, the witness statement must state the town or city and the county of the subscribing witness. It was not done properly, and I don't think having a hearing would be necessary for the court to come to that conclusion. Simply the face of the petition, the face of the designated petition, speaks for itself. In addition to that, I would go back to it just mentioned that those signatures, those pages, had been objected to by Mr. Palmisano, and also raised in my answer.
Okay.
If there are no further questions, I'd rest on my papers.
Okay, thank you.
Thank you.
Counsel?
Good afternoon, and may I please the court? I'm Jessica Culpet. I'm here on behalf of Tracy Matrano. And I would ask your honors today not to disturb the determination of the Yates County Supreme Court and keep Tracy Matrano on the ballot for the Working Families Party line for the office of Representative in Congress for New York's 23rd. This brief is without merit on the facts or the law. Even in this unprecedented pandemic times, the Yates County Court ordered an in-person hearing and made all the witnesses arrive and testify in person. Their credibility determination should not be removed. First, the Supreme Court has the jurisdiction to hear and differ from the Board of Elections. I've outlined it extensively in my brief, which I know has been reviewed. And the Board of Elections and the Supreme Court serve different purposes. The Board of Elections made the determination on the face of the petition only that this was an alteration or modification. We presented live testimony under oath in person that it was not. The court referenced and made a determination based upon the hearing, the testimony, and their credibility that it was a stray mark and not an alteration or modification. That should not be disturbed. Finally, the Supreme Court was valid only in allowing testimony regarding the validation of the order to show cause. The court is correct in addressing the fact it wasn't re-objected to, and there was no invalidation proceeding filed at the proper time. If the objector wanted to, after petitions are filed in the designated amount of time within the election law, he can file an invalidation proceeding to preserve any argument he wants to make if the board doesn't go his way. He didn't do that. He's precluded from those additional arguments here. I would leave it up. Apologize. The invalidation must be filed. The cases cited by petitioner are distinguishable as they discuss the ability to validate a petition, not invalidate. There's nothing before this court in way of precedent that says we should argue additional signatures that weren't removed by the board when an invalidation proceeding is not filed. For all of those reasons, the court should not disturb the finding below, and Ms. Matrano should appear on the November 3rd ballot.
Thank you.
The court will stand in recess.